stands adjourned for 2 weeks. List accordingly.
Wait, please, your lordship. Lordship, I beg to mention item number 10 from today's, my lord. My lord, there is some typographical error in the petition, my lord. So I may be allowed to correct it by the help of registry, my lord.
No, you cannot overwrite.
I will change that, my lord.
Hmm?
Synopsis
You can
page,
do
my lord.
nothing. You have to file amended petition.
Okay, then I will file the amended petition, my lord.
Or you can withdraw and file a fresh, whatever you want. Overwriting is not permissible. That used to happen sometime back. Now it's no longer permissible. All right, you make a prayer when the matter is called up. Next matter, please.
May I please, your lordship, with the consent of all the parties, I beg to mention item number 39. Yeah. In this case, I am being led by K.N. Chaudhary, sir. He is on leave till 10th February.
Item number?
39. The matter may be taken after 4 weeks, your lordship.
I'm for the second.
With the consent of the opposite side, Mr.
R. Paul,
R. Paul, learned counsel appearing for the
respondent 1, 2, 3, your lordship.
respondents 1, 2, and 3.
Lordship, she is for the respondent number 4.
Respondent number 4.
6 adjournment in this case for 3 weeks on the ground that the arguing counsel is on leave. Since the prayer is not opposed, same stands allowed. The learned counsel for the late petitioner, for the applicants, as well as the respondent number 4 are present.
Highly obliged.
May it please the lordship. Lordship, item number 25. Since Mr. Medhi is out of station, he is appearing before the Aizol bench. It may be taken up on 5th of February.
No, that I can't say. You want to pass over, I can give you item number.
25.
You have informed the other side.
Yes, lordship.
You are praying for the petitioner.
Hmm?
We are praying for the petition.
With the consent of learned counsel for the petitioner, a prayer for adjournment has been made in this case by the respondents' counsel on the ground that the learned CGC, Mr. Eskin, is unavailable. Since the prayer is made with the consent of the other side, same stands allowed. This matter stands adjourned for 2 weeks. Yes.
Obliged.
Your Honor, I am praying for listing of the case which relates to service matter. It was last heard on 22/9/23. So it is 3 months already passed. I request for the respondents to submit the
Next week,
affidavit.
next week, put a date next week.
Next week.
May I first, lordship. Lordship, I beg to mention the admission matter, lordship. It is listed 3 months ago, lordship.
Next week,
Similar prayer, lordship.
next week.
Right.
Yeah, apportion the dates next week.
Daily list promotion.
Which order has been violated?
May
Which
I
order?
please, your lordship? My lord, the order is at page 11, my lord. Lord, it is in the nature of an interim, my lord. Operative part, my lord, is at page 13.
But why have you filed a document which is already marked? Don't you know that this is not permissible?
My lord,
It's not permissible. You can't do that.
my lord.
Give it to him.
The document, mark. No, it was Ami Purana. Lord, perhaps it has not from our end, my lord. It has come up earlier also, my lord. Not from my side, my lord. Wait for that, my lord. Marked by pencil, perhaps, my lord. Because, my lord, if we had filed, registry would not have passed it, my lord.
All right.
My lord.
Maybe you're right.
Even
Yes.
then, my lord, I am sorry, my lord, if something is.
No, it's all right.
My lord.
I thought this matter was listed for
My
the
lord.
first time. So what has not been done here?
My lord, promotions, my lord, the direction which has been given in this paragraph, my lord, has not yet been complied with, my lord. That is one contention, my lord. And even then, my lord, as this is an interim order, my lord, in the main writ petition, my lord, which is marked as an item number 2, my lord. This honorable court, after going through the, my lord, records, was also asked for the record that at what stage my departmental proceeding is, my lord. Now, my lord, the record has been called
We
for.
can complete the proceeding within 3 months, my lord. Departmental proceeding is going on, my lord, and he's under promotion, my lord, under seal cover proceeding, my lord.
How this direction can be complied with?
My lord.
Cannot be done.
My lord, my proceeding initiated in the year 2014, my lord.
No, that's not the point.
My
Point
lord.
is, if there is a seal cover proceeding.
That is correct, my lord.
DP is
That is correct.
pending.
I
This-
can understand, my lord.
I
I'm sorry
already
to
have
say,
filed a
with all
petition.
respect, this order is not.
My lord,
implementable.
my lord. Then, my lord, I may not pressing the contempt at this moment, my lord.
All right, in item to you, right, I heard Mr.
Mal.
Bhuyal and counsel for the petitioner, also heard Mr. S. Dattal, understanding counsel CNRD Department Assam, appearing for the state who submits an instruction that the department, the consideration of the petitioner for promotion is kept under seal cover due to the pendency of the departmental proceeding. And it is department proceeding. Full stop. It is also submitted that the departmental proceeding will be concluded within a period of 3 months from today. Therefore, the learned counsel for the respondents has prayed for posting this matter again after 3 months. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after 12 weeks for necessary orders.
My
In the other matter, item 1 so and so for Mr. A.R. Bhuyal, learned counsel for the petitioner submits that in view of the order dated as it date passed in the item number 2, he be granted leave to withdraw this contempt case with liberty to file again as
My
and when appropriate stage arises. On the submission of Mr. Bhuya, this contempt case stands closed for now. The petitioner would be at liberty to approach this court at an appropriate stage if the assurance given by the learned departmental counsel in item 2 is not complied with.
Obliged.
Obliged, my lord.
Yes, yes.
May I please, my lord, for the time being, my senior is trying to connect through BC, but it is not connecting right
Who is
now.
your senior? Who is your senior?
NK Mure,
Huh?
NK Mure.
There is no request for VC. You cannot connect.
For the time being,
What is this matter about?
Our compassionate appointment, Lord.
No, but what will you do for the time? He is coming to the court.
I will discuss with him.
You will discuss. Discuss. Have a hot discussion. Yes.
Item 4.
May it please your lordship. My lord, the respondent was supposed to get instruction, my lord.
My lord, regarding instruction, my lord, I wrote a letter, my lord. We have not received any instruction. Whether appeal has been disposed of or what is the status of the appeal. So let it be done next week, my lord.
My,
Otherwise,
twice, my lord. 2 times, my lord. My lord may pass an appropriate order, your lordship. Everything was finished in the.
Notify, so then-
Next week, if the instruction is not made available, who is the officer? He will remain.
Officers, Commissioner, Secretary, my lord, Revenue Department.
Heard Mr. S.K. Ms. S.K. Bhopal,
Land and Revenue Department.
petitioner. Also heard Mr. T.C. Chupia, learned additional civil government advocate Assam submits that instructions have, as called for, are still awaited. Mr. J. Hendrik, learned SC Revenue Department Assam is also present on behalf of the respondent number 1. Full stop. I find from the record that by 2 consecutive orders, that is order dated 2012-2023 and 8/1/2024, this court had Granted time to the learned departmental counsel to seek instructions. However, as it transpires from the submission of Mr. Tutia, despite written communication made to the concerned officer, no instruction has been received till today.
Lordship, my lord, that earlier, my lord, that it was before the, my lord, the law division commissioner, lordship. Whether the matter was pending and there, whether the matter was disposed of or not, my lord, it cannot be said. My lord, it cannot be transferred to the, if it is disposed of, cannot to the, my lord, the transfer to the, my lord, the commissioner second, the principal secretary.
Today also, another prayer has been made seeking further time for obtaining instruction. From the above, it is clear that the departmental authorities are not responding properly to the order of this court. Be that as it may, on the request of learned counsel appearing for the respondents, one final opportunity is granted to them to seek instruction. Registry to therefore list this case again on 2nd of February 2024 for motion. It is made clear that if the instructions as called for are not made available on the next date fixed, this court will consider directing personal appearance of the concerned official first to appear and assist this court in the matter. Copies of this order be furnished to Mr. Chutia and Mr. Hendik in the course of the day.
Oblige, your lordship.
Item 5.
May I please, Lordship?
Yes, which order has been violated?
Lordship, page 11 is the Lordship order. And operative direction is at page 13, Lordship. Regarding Lordship, area of salary, Lordship. Pension loss, pension revenue.
Mr. J. Abbas or Bakiti लिखित 8 weeks. Multiple respondents, raise the post steps.
Loss, oblige me.
6.
May it please your lordship, on last occasion, this honorable court has directed me to take instruction as lordship. I have received. Lordship, the petitioner is receiving the minimum of the pay scale and his case is covered by the Upendas. Regularization cannot be because he was engaged on post 1/4/1983 and pensionary benefit is not entitled, my lord. Lordship, Upendas judgment paragraph 22 and 23.
Are you happy? No?
My lord. Let them file affidavit, my lord.
Oh, are you happy or not? Tell me, what more do you want?
No, pensionary benefit and regularization, my lord.
That is not possible.
No, because my lord, my case is covered by
Mr.
the.
Sinha, the problem is you have not read Upendas.
My lord.
That is the problem. If you had read Upendas, then you would have engaged in a
No,
meaningful discourse with the court.
Upendas, my lord, those who have been subsequently, my lord, appointed, my lord. But my case is, my lord, it has been already processed.
Do you have Upendas with you?
No, now I don't have Upendas
Yes,
case.
I
my lord.
have 22 and 23.
No,
I have written
But the
copy.
thing is that my case has been well processed, my lord.
No, this is different, but
Cannot
his
be done.
How can I see?
process is different.
No, my cases has been processed, my lord, as per judgment and order of the Supreme Court, my lord. Your lordship will file.
No, let them file affidavit saying what?
Whether Upendas is covered my cases or not. But the
Yes,
thing is, my
covered.
lord,
Today I am
because-
submitting.
Because my lord, long before my lord, when the Supreme Court judgment has come, my lord.
I'll pass a judgment today itself. When was your client engaged initially?
My lord, on 8/4/93, my lord.
And what is the cutoff date? As per
1/4/1983.
1/4/93. Just wait.
So he was engaged after the cutoff date.
Yes, my lord.
Okay, now which is the relevant paragraph of Upendas?
22 and 23. Lordship, 22 is enough. 23 is also declaring pensionary benefit.
Fantastic. Lord.
Yes, Mr. Sinha,
Lordship,
please make your
another-
submissions. I'll dictate the judgment.
Lordship.
You
And
see, there is no point unnecessarily prodding. You are a lawyer.
No, no.
You have to argue logically and as per the law.
Of course, my lord.
You
That
obviously know that this relief cannot be granted, but merely because the court gives you the liberty to argue, you will go on saying whatever you want.
my lord.
That is the problem with many
The here
counsels.
difference is there, my lord. Only there.
Ah.
On the day of judgment passed by Supreme Court in Umadevi case,
Hmm.
already on that day I have crossed the 10-year service, my lord.
Doesn't matter. You have not read this judgment. You have not read para 20. Anybody after 1/4/1993 cannot be regularized. That's the law. Regularization cannot happen just like this. For that, there is a scheme. There has to be a scheme of regularization. It has to have cabinet approval. The government has not regularized the service of
And my
any
lord,
casual worker after 1/4/1993. So your clients cannot also be regularized. So I'll pass that order. You can take another 10 minutes,
Ma-
but that is the order
lord,
I'll pass.
that order, my lord, that order 1/4/93, in case of others, my lord, not for me, my lord. Those who have been appointed in the year 1993 and all, my lord.
All right.
Because Supreme Court case has been covered, my lord, for them, my lord.
Lordship,
But subsequently, my lord, after
Please take your.
subsequently, my lord, 95, 96, 97, 98, even 2001, they have been appointed on casual basis. And after that, they have crossed 10 years. In respect of those candidates, my lord, the open dash is applicable. my lord.
No, sorry.
But
that's
on
not
the day of the Supreme Court passed the judgment, my lord, on 10/4/96, my lord, so 2006, my lord. So on that day itself, I have covered by the judgment Supreme
There's
because
no
I,
such exception. You show it from the judgment where the exception is made.
yes, my lord.
Hmm.
My lord, that Supreme Court judgment, my lord.
Whichever judgment, show
Yes,
where the
madam.
exception
Yes,
is
madam.
made.
There you are to the. Sorry, to the.
Mr. Sinha, you may not be aware, and there's nothing wrong about it. The fiction in Upenda's judgment was initially broached by a bench where I was a partner, and the suggestion initially came from me. So I know the circumstances under which it was made. Of course, when the judgment was passed, by that time the bench has changed. The government said the question of regularization does not arise, and they were correct. Then we said you must give them some benefit. They have spent so many years.
That is scale they have given, my lord. But the thing is, that even the
Reserved. Yes. Next one.
deeply obliged, my lord.
The last question.
Lordship, I have not received full instruction, but some instruction I have received, Lordship, that a departmental proceeding was initiated under section 153.2.1 of RPF rules. And here his allegation is that the person who is subordinate to the disciplinary proceeding was appointed as inquiry officer. But our rule 153.2.1 of this RPF rules submits that a person who is above the rank of the person against whom the inquiry is there and who should not below the rank of inspector can be appointed as an inquiry officer. And this as per 153.2.1, and they had proceeded under that appointed him, Lordship.
Rule 150.
3.2.1 of RPF. Railway protect 153.2.1.
So here the enquiry officer is of the same rank.
Below the rank.
Below rank.
You can't do that. 153.2.1 does not permit it.
No, not below the rank of the enrolled person. He is the below the rank of the disciplinary authority. The enrolled person is a constable. So here he is above the constable.
So he is below the rank of whom?
My lord, he's below in the rank of the fact-finding authority, my lord. Officer who
That
has,
is okay. That is not bad.
and one more thing, my lord, your lordship, kindly say.
Just a minute, just a minute. You are completely, the delinquent is a constable.
Yes,
And what is the rank of the,
IPF. So IPF. His rank
IPF.
is written as IPF oblique RPF. So he is
Inspector.
inspector.
so what is the problem? He is higher in rank.
My grievance is that, my lord, the authority who has conducted the fact-finding, my lord,
Hmm.
my lord, may not be possible for him
No, whether
because he's
possible
below
or
in
not
the
is-
rank. He'll be influenced by that, my lord,
No.
by the
no.
fact-finding.
No,
authority, my lord.
where does the law bar it? You
And
show me that.
one more thing, my lord. Here in this case, my lord, the person who has acted as a fact-finding authority, my lord, he is the authority who is functioning as a disciplinary authority.
Hmm.
The same person.
Yeah.
My lord, I am the fact-finding and inquiry officer, my lord, and I am the disciplinary
Of course
authority.
they can.
This is
Absolutely they can. It is even permissible under 153.1.
No, my lord, the disciplinary authority and the fact-finding authority are the same person. This is in violation of the Review Board's letter, Annex
Alright, we
6.
just issue notice.
Lordship.
Your lordship, kindly see Annex 6 once, my lord.
Hmm.
Annex 6.
There is nothing in this. These are completely
This is a
misconceived.
different point, my lord. Annex 6.
Yes. Yes, so we'll see if the facts suggest we'll set aside. Your client will be free. Let them file affidavit.
In that some protection may be given, but it is in violation of this
This
instruction, my
is
lord.
68 lordship and rule is of.
We'll make it clear that if it is in the next date, if we find that it is in violation of any rules, the consequential orders will follow.
Yes.
Yes, heard Mr. Aeropic Learned Counsel for the petitioner. Also heard Ms. B. Sharma, Learned CGC, appearing for the respondents. Respondent नहीं लिखी बोलनी, respondents लिखी बोल. Respondent who submits that instructions as called for on the basis of the order dated 11/1/2024 passed by this court are still awaited. Having heard the submissions of learned counsel for both the sides, and also after going through the materials on record, more particularly Annexure 6, bracket close, bracket or Annexure 6, this court is the opinion that the matter would call for further examination. As such, issue notice of motion returnable on 26th, no, you make it 4th of March 2023. Since Ms. Sharma has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, etc., etc. Hard on the prayer of interim relief. The said prayer will be considered on the returnable date. The respondents to bring their stand on record by filing affidavit before the next date fixed for consideration of the interim prayer. It is also made clear that any consequential order passed in the meantime shall be subject to the outcome of the writ petition. Any consequential order passed against the petitioner in the meantime.
Lordship, please.
By the last order passed on 12th of January, Lordship, in fact, directed the respondents to obtain instruction as to what has happened, because my learned friend grievance basically is if his name was not included in the list of candidates to be called for interview, if it is rejected, he should be informed. And if it is not rejected, it should be a further process. So he's in the first stage, not in the second stage. My Lordship will give us just 1 week's more time. We have not received the instruction. Next Monday we'll face because there are other matters. There also
But what is this, so much of litigation being generated on this?
I mean, no, in other cases, the secretary who is participated, who is the chairman of the committee,
Mhm.
he, according to the petitioner, is not competent. Because he has not completed in the required number of services to act as the district judge, and therefore he should not have been included in the committee. But he was appointed possibly by the Honorable Court, my lord. We'll find out, my lord. He is actually on deputation. Possibly they are not aware of this fact. He is not a regular appointment. So on that ground, possibly those I will argue on that case.
Oh, the LRs and judicial secretaries, joint secretaries are always on deputation. Yes.
Yes. So
That's-
if
that's
he's
what I-
on deputy, because in other cases, there is a challenge seeking a writ of quo warranto, and he cannot hold the office, he is not competent. But he is not a regular appointee, he is a deputy on deputation. So if he is not a regular appointee, writ of quo warranto cannot be issued. I'll argue in that case, the issue is slightly different. Possibly they are not aware of this fact.
I have not challenged that procedure. I am on a slightly different procedure because I am on the step A.
He's on
So if
step
my
A.
learned friend needs that time, I have no
Just
problem.
1 week's time, I'll come up with this.
My only request is if some kind of a protection till then, because as far as I know, the selection process now seems to be completed. I don't know whether the list is available or not. Because this is,
No, Mr. Majumdar, you want 1 week's time for what?
Well, place the instruction as to what has happened to him.
Kwame.
His case is different.
Kwame.
I mean, he is not saying that I am selected or I have been deprived. He is only saying that if his name was not included in the list of candidates to be called for interview, what is the reason he has to be informed under the rules? And he has not been informed. So that much. He is on the first stage, not on the second stage. So Lordship will kindly give us 1
No, but now even if you inform, that will be vitiating the
Yes,
system.
that is my difficulty.
And when has he come? Can he come now? After everything is over, he has come now. If he wants to stop the second stage, he should come before the second stage
No,
begins.
that is all right.
My lord.
But if the law says, the statute says that if a person does not qualify,
My lord.
he has to be informed.
Yes.
Violating that statutory provision will have its consequences.
My lord, if he has not been informed, and all right, supposing he has not been informed for a reason, it has been rejected. All that opportunity he will get is to meet the objections if there is any against him. But that doesn't entitle him to get the direction for my lord, being appointed as a notary public.
Correct.
Directly.
But what is the remedy for the petitioner on that?
Remedy, my lord, he will have to see my lord, if the objections are genuine, is for him to meet the objections.
You do it day after
my-
tomorrow or Friday.
Friday.
Or Friday is a holiday, Thursday.
My lord, let it be on Monday, just a couple of days, my
A
lord, in
slight
between.
difficulty on Monday. Otherwise, it has to be pushed on first. May I just request if it is not difficult for my learned counsel to be on Thursday, or else it will be maybe a request.
Mr. Majumdar, let's see on Thursday.
Let's try a luck on
It's
Thursday.
not a very big thing.
My Thursday, I have got some difficulty, my lord. There's some personal problem to, I have to go to Nagaon, some personal problem.
Going somewhere.
No, no litigation. Let it be on Monday, I say.
Why don't you both agree on a date?
Yes.
At least spare the judges on that.
Can you keep it on first? I'm extremely grateful. I have a slight difficulty on
Mr.
29th
Abdul
and
Learned
30th.
Counsel is present for the petitioner, Mr. D. Majumdar, Learned Additional AG Assam, adjourning for the state, has sought posting of this matter again on 1/2/2024. On the ground that complete instructions as called for are still awaited. Considering the submission made by the Learned Additional AG Assam, the prayer stands allowed. Register to list this matter for motion again on 1/2.
Grateful.
Item 10.
May it please your lordship. Lordship, there is some typographical error in the synopsis page, my lord.
No, Mr. Upadhyay, those earlier practice which was allowed,
Yes,
that is actually not in accordance with law.
yes.
And the problem in this court is that this court goes as per law. So tell me what to do. You cannot do overwriting in the
Let me
petition.
file an amendment petition, my lord, for that. I will file an amendment petition.
What is the mistake, by the way?
Mistake is there, printing mistake, my lord.
Printing mistake.
Printing
What
error.
is the mistake?
My lord, dates and the WPC numbers are different, my lord.
Sorry,
Date and WPC numbers are different.
which page? Which page?
Synopsis page, my lord.
Oh, that you don't worry. Synopsis will take care. Yes,
Well, he was minor when the petitioner father was died. It is appointment on compassion and ground. Lordship has already decided the issue, my lord. And the
My lord-
other cases already, there are another case filed by the petitioner which lordship was fixed. There is also another cases there, my lord.
What is the date of that? What is the number of that case?
My lord, it is, my lord. Which lordship,
That is still pending.
well, another case is pending, my lord. This case is lordship has already decided the issue.
My
In
lord,
this court.
I would like to submit something more, my lord.
Hmm.
On the earlier date, my lord, on the earlier round of litigation, my lord, in contempt petition, my lord, contempt petition was closed at, as it was termed, my lord, premature.
My lord, case also, lordship, it premature, lordship, DLC has not been held, lordship.
My lord, after so many years, the DLC has not been held. Yet.
Yeah, who died?
My lord, father of the petitioner died
When?
12/10/2015, my lord, serving as a night chowkidar, my lord.
What to do? This court has already passed judgments in these matters. Different judgment on same kind of case is not possible.
My lord, may direct the respondents to place the case
DLC has
before
not
the
been
district
recommended,
level.
lordship, as the DLC has not been held, lordship. Whether it is a premature case, lordship.
My lord, when DLC will be held, my lord, that is the issue.
Well, as per the, my lord, 2015 notification, the time limit for submission of the, my lord, application is 1 year. And at that time, the petitioner was minor. And when he became major, my lord, then he filed a petition after.
When did he file it? When did the petitioner file?
7/12/2015.
Died on 12/10/2015. And the petitioner's date of birth is 1/1/1990. And at that time, he was 15 years old, my lord, when the father of the petitioner died, as per the, my lord, application submitted by the petitioner himself. So there is no question of consideration, my lord. As per rule, also, my lord, the time limit for filing it is 1 year. Petitioner annexed that notification of the government also.
My lord, there is earlier direction also from this honorable court, my lord, to place the matter before the appropriate DLC. Now they are saying this, my lord.
No, but it cannot be done. What will the DLC? DLC cannot recommend your name.
And there is no DLC now, my lord. The appointment of compassionate ground scheme has all been abolished also, my lord. At this phase application, consideration also
Right,
cannot be done.
Mr. Upadhyay, you have tried. Heard Mr. S. Upadhyay, learned counsel for the petitioner, also heard Mr. J. Pritya, learned standing counsel PAC Assam appearing for the passport numbers.
I am appearing 7 and 8 blocks.
I am 1, 2, 3,
1 to
5 and
6.
6.
1 to 6.
1, 2, 3, 4, not my lord. PDO, please sit in there. 1, 2, 3, 5 and 6.
Mr. R. Dhar, learned SCPWD for resport number 4, and Mr. H. Chakravarti, learned GA Assam for resport number 7, 8, and 9. First up. This writ petition pertains to the prayer made by the petitioner for appointment on compassionate ground. It appears that the father of the petitioner died in harness on 12/10/2015 while he was working as a night chowkidar under the assistant executive engineer, PWD, bracket R, bracket close, Kherani subdivision in the district of Karbi Anglong, bracket west. At that time, the petitioner was a minor, aged about 15 years. Upon attaining majority, the petitioner had submitted an application, majority, that is 18 years. What is the date of submission of application?
Date of submission of application is 7/12/2015, madam.
But at that time, he was a minor.
Yes, my lord.
That is last line to any at the time of death of his father, the petitioner was a minor, aged about 15 years. Notwithstanding the same, on 7/12/2015, an application was submitted by the petitioner for appointment on compassionate ground. However, the same was not considered due to the apparently due to the minority of the petitioner. Full stop. Earlier, the petitioner had approached this court by filing WPC number 302/2021, ventilating his grievance in the matter, which was disposed of by order dated 12/3/2021, with a direction upon the respondents to place the application of the petitioner for compassionate appointment before the concerned DLC in its next meeting. Full stop. When no such action was taken in the matter, the petitioner has approached this court for the second time, seeking a similar order. Full stop. It is to be noted herein that the scheme for appointment on compassionate ground has been withdrawn by the state of Assam way back in the year 2017. As such, the question of holding DLC for processing applications for appointment on compassionate ground as on the date of the order dated 12/3/2021 may not arise in the eyes of law. However, it appears that the said aspect of the matter was not brought to the notice of the learned single judge, passing the order dated 12/3/2021. Be that as it may, the fact remains that, be that as it may, the undisputed fact of this case is that at the time of death of his father, the petitioner was a minor. As per the standing government circular issued in the year 2015, an application seeking appointment on compassionate ground had to be made within a period of 1 year from the date of death of the government employee, failing which the same would not be maintainable. Full stop. However, in the present case, since the petitioner was a minor, in the present case, although the application was filed within 1 year, yet since the petitioner was a minor on the date of submission of the application, the same could not have been considered by the authorities. Full stop. Subsequently, the petitioner had attained majority, but that was after a lapse of more than 3 years. Full stop. In a recent decision of the Supreme Court, rendered in the case of State of Manipur versus Muhammad Rajauddin, reported in 2000, recent in a decision of this court, reported in 2003/7 SSC 511. It was observed that in the absence of a circular by the state permitting a minor to submit application for appointment on compassionate ground upon attaining majority several years after the death of the government employee, no such application would be maintainable. Full stop. By relying upon the said decision, this court had passed order dated 12/12/2023 in WPC number 6916 of 2023 in the case of Tapan Saikya versus Chief Secretary cum Chairman State Level Committee for Compassionate Appointment and others, holding that a belated application filed seeking application of compassionate appointment by a person who was a minor at the time of the demise of the government employee would not be maintainable. Full stop. It was also observed that after several years of After several years has passed since the demise of the government servant, the element of compassion would not be present in such a case. Full stop. Having regard to the peculiar facts and circumstances of the case, this court does not find any justifiable ground to adopt a different approach in the matter. Moreover, it has been time and again reiterated that appointment on compassionate ground is not a vested right, but a gesture of compassion shown by the state so as to mitigate immediate hardship arising due to the demise of the sole bread earner of the family. Full stop. Therefore, such an application has to be considered strictly in terms of the letter and spirit of the standing government circulars and by taking note of the element of compassion and immediacy factor involved therein, which in the opinion of this court is totally missing the present case. For the reasons stated here and above, I do not find any merit in this writ petition. The same is accordingly dismissed.
I'm highly available.
Item 11.
Please, your lordship, my lord, matter pertains to compassionate appointment, my lord, the railway department going to appoint, my lord, the respondent number 6, my lord, he is the widow of the deceased, my lord, and he is subsequently, my lord, prepared to remarry, my lord. That the petitioner being a, my lord, son of the deceased, my lord, filed application, kindly see, my lord, page number
This is
36.
NF Railway, Union of India.
Union of
Yes,
India. At this stage, notice may be raised.
Well, he has come in apprehension that, my lord, this daughter-in-law of the petitioner, she might approach the authority seeking compulsory appointment. My lord. In apprehension, he has come.
No, she is the
Because-
mother.
Yes, my lord, mother, my lord.
What does she want?
My lord, he is, my lord, there in the railway department, there is a provision to reserve the post, my lord. Till, my lord, attain majority, my lord. There is a guideline, my lord. And the petitioner, my lord, seeking, my lord, to reserve that post to grandson, my lord. Because, my lord, after death of the deceased, my lord, the respondent number 6 left the house of the, my lord, petitioner, my lord. And he is a parental house, my lord.
Only
If
issue
he
notice
made
at
it,
this
my lord.
stage. Heard Mr. K. Padgiri, Learning Counsel for the petitioner. Here is the amendments made in the writ petition. Mr.
MR Adhikari, my lord.
M.R. Adhikari, Learned CGC appearing for the
1
response.
to 5.
Numbers 1 to 5 praised for some time to obtain instruction in matter. NOM 8 weeks since Mr. Adhikari has appeared and accepted notice for response numbers 1 to 5. That is all the respondents, is it? No.
6, 5, get
No
respondent.
formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to Mr. Adhikari within 3 days from today. Petitioner to take steps for service of notice upon respond number 6 by registered post to JD.
My lord. All right.
Item 12.
May I please your lordship? Lordship, kindly pass over the matter for the day. My colleague who prepared the case, she is sick. So we need some instruction from the client. We are not able to get.
We'll have it next week then. All right. On the prayer of learned counsel for the petitioner, this matter stands passed over. This case for motion again in the next week.
Please.
Item 13.
Lord, petitioner is agreed with his non-selection to the post of Gao Pradhan. The
Now
person-
present file appeal.
As
Already
per
have
section
filed appeal.
162.
Yes, appeal was filed, lordship, but it was not acted upon, lordship. Now there is no existence of the office. We have the number, lordship, that I have mentioned in the writ petition. Now the person who has been selected, he is an active member of a political party, lordship.
So what is the problem?
As per the
Which political party?
is the ruling party, lordship.
And what is the problem?
And now the problem is there is a violation of the terms of the advertisement, lordship.
Is it violation?
Yes.
My lord,
Advertisement specifically
advertisement
says-
specifically, my lord, that he should not be any member of the political party or my lord.
That is there.
No, you expect ruling party to appoint people from the opposition party. Now, is that your expectation? All right, you will issue notice.
Let's see. My lord, appeal filed before whom, my lord?
That was filed before the Lower Assam Commissioner, Lordship.
My lord,
You will get enough time to obtain instruction. Heard Mr. Ganguly Learned counsel for the petitioner. There is the amendments made in the read petition. The petitioner is basically assailing the selection and appointment of the respondent number.
Four.
Respondent number 4, is it?
Four, yes.
In the post of
Gav Pradhan,
Gav Pradhan of
Paskuri Village, District Borpeta, charge number
Kashkuri
20.
village, district charge number
Charge number 20, my lord.
of
Come on.
Kashkuri village in the district of Borpeta. Mr. Ganguly submits that even the appeal preferred under the provisions of Rule 162(c) of the executive instructions framed under the Assam Land and Revenue Regulations by his client before the
Commissioner Lower Assam Division.
Commissioner Lower Assam Division has not been disposed of till today. Mr. J. Hending, Learned Standing Counsel, Revenue Department, Assam, prays for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Hending has appeared and accepted notice for respondent number 1 and 3.
Only one, lord.
Only one. And Mr. R. Dhar, Learned Additional Senior Government Advocate, Assam, for respondent numbers 2 and 3. No formal notice is required to be sent to the state respondents. Extra copies of the writ petition, requisite numbers will be furnished to the Learned Government Learned Department Council so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 4 by registered post to PD.
Four, no? Four.
May it please your lordship. In this case, your lordship, I was promoted from the post of assistant sub-inspector to sub-inspector in the year 2013, but my rank was not confirmed. A list was published, your lordship, on 26/12/2023, whereby the other persons similarly situated like me, their ranks were confirmed, but my case was not considered, your lordship. I'm only aggrieved by the fact that I will retire on 31/3/2024. Lordship, may kindly peruse page 28.
Just a minute. Who is appearing? Yes, what do you have to say?
My lord, at this stage, I will seek instructions, my lord. And my lord, one thing, my lord, suppose my lord interferes with the list. The person
No,
in the list will be.
that is something else. If a right has been violated and the only way of correcting is to interfere with the list, then we will have to do it.
My lord.
That's not the
My
point.
lord, you can't be sometime. Let me seek at least some instruction, my lord. Let it come after 10 days, my lord. He is retiring in March. Still, we have some time. Before that, my lord, we'll try to, my lord.
It's a 10 days for motion.
Motion, my lord. In motion, my lord.
Yes, your lordship.
Yes. Heard Mr. T. Devi, Learned Counsel for the petitioner, also heard Mr. R.
May I submit one more thing, your lordship? Training is organized, your lordship. May I be allowed to take part in the training, your lordship? May kindly peruse page.
No, what is it?
With respect to the others, your lordship, at page 37, page 34, your lordship.
No, training is organized by whom?
Training with respect to the other persons, your lordship, who are selected. They will be given training for a period of 2 weeks. This is to be held on.
So the whole training should be stopped.
No, I want that I may be allowed to take part in the training. I had made a prayer also in the interim, your lordship.
Training will start from when?
29/1/2024 for a duration of 2 weeks.
29/1 to 27.
Then we'll have it on 29. You get the instruction.
Mild.
We'll consider. The Dairy Learned Counsel for the petitioner also heard Mr. R. Dhar, Learned Additional Senior Government Advocate, Assam, appearing for the official respondents. Considering the nature of grievance expressed in the petition, Mr. Dhar seeks posting of this matter again on 29/1/2024 24, was to enable his client, first to enable him to obtain preliminary instruction responding to the grievance expressed in the writ petition. Prayer allowed. Is this case for motion again on 29/1/2024. Two extra copies of the writ petition be furnished to Mr. Dhar. On the next day fixed, Mr. Dhar to also obtain instruction and respond to the request made by the petitioner's counsel so as to provisionally allow his client to participate in the training program commencing from 29/1/2024. You want a copy of this order?
My lord, it will be,
Copy of this order be furnished to Mr. Dhar. In any case, you will get it from the internet.
once it is uploaded, I'll get it.
I'm deeply obliged, Your Lordship.
Here is one difficulty, madam. The select list will be expire on 30, my lord. So I have a prayer in the interim, my lord, till disposal. Because I will be allowed to file independent writ petition, praying, my lord, extension of the select list, my lord. Otherwise, it's not common judgment, my lord.
Which case? Which case?
My lord, disability case, my lord.
Okay, you are making this submission in item 15.
Yes, my lord.
What is your prayer?
Prayer, my lord, was, my lord, the select list, which will be expire on 30 January, my lord. The prayer was the till disposal of this writ petition, my lord. And my lord, there is another bench of which has been disposed of, my lord, directing the my lord, disability case, my lord.
Achha, those matters were
Yes.
benchmarked.
Yes,
So
yes.
have they communicated to the petitioners? What is the nature and extent of finding?
No. Till date, we have submitted in other matters, but till date, they have not.
Now, what is the problem here?
Yeah, my lord, this advertise, the different advertisement, 2018 advertise. Here the select list was issued on 31/1/2023, my lord. So normally 1 year, my lord. 30 January, my lord, 2024 will be expired, my lord. My lord, this writ petition may be disposed of, my lord, with liberty, my lord, file another independent writ petition praying, my lord, extension of the, my lord.
No, where is the order, earlier order? Is
Earlier
it
order, my
annexed?
lord.
There is already liberty granted. That you don't need liberty. You can always do it.
Yes.
Disposed of.
Yes.
Mr. S.K. Roy. So Mr. D.P. Bora. You are appearing for whom? Disposed of.
Right.
That you can always find. This is difficult.
Item 16.
Disposed of.
May it please, your lordship.
Yes.
So this writ petition is filed impugning the order of the passed by the commandant, your lordship. You
Passed by
the commandant. The petitioner was serving as a BSF personnel in the capacity of constable. He was made to retire, your lordship, due to overstay of leave. He was overstaying leave due to medical reason. The same was placed before the authority, but that was not considered, your lordship.
Yeah, that's okay, but what is the grievance here?
The grievance is that we have filed a representation before the authority, your lordship, to consider.
No, Mr. Bora, we are not concerned whether they are made to retire or not.
Lordship.
We are only concerned if it is done in violation of the law. That you have to tell us.
Your lordship, the thing is that
Otherwise, who is doing what, where the courts are not.
at the time of undergoing a commando course, the petitioner have faced some
You have
health
probably
issue.
not heard the query properly.
Lordship.
Unless you hear it, you will not move an inch forward. I'm saying unless you make out a legally sustainable case,
Lordship.
we are not concerned. Who has overstayed leave, who has done what, that's none of our concern. But we will be immediately stepping in if we find somebody has been, his or her rights have been violated, etc. Then the judges and courts will look into it. You have not stated anything what right has been violated.
Your lordship, he was made to retire compulsory, so he have put in 17 years of service, your lordship. And now due to the compulsory retirement, he was abstained from getting.
So it is inconvenient for him.
Your lordship.
We don't enforce convenience.
Lordship is pensioned.
Convenience, ego, and all these things are not enforced in a legal proceeding.
And his health condition was also not considered, your lordship. That is our main grievance here, your lordship.
Maybe.
And that health condition
You
is.
have to tell us what right has been violated, Mr. Borgohain. You can't even find out that right. How will you write it? You are unable to say after the fourth query by the judge what right of the petitioner has been violated. And unless there is a violation of right, the courts cannot step in. Otherwise, you show us the law which says, yes, even if no right is violated, the court can look into.
The representation filed by the petitioner, your lordship. And
We are not concerned. Representation, hundreds of representations are filed everywhere. We can't go on. What right of the petitioner has been violated? You have to say that. Otherwise, I'll close this petition.
lordship, at
You
the
agree that the
Lordship.
court of law is to only look into violation of rights,
lordship,
arbitrary exercise of power by the authorities, is it not?
lordship.
You have not mentioned anything. You are not even able to say orally also.
Because at the time of training, he had suffered the injuries, your lordship, and that should be considered at the time of.
List for dismissal on 29th. By then, if you can come up with an answer, otherwise I'll dismiss it.
Item 17.
Is for motion.
May it please your lordship.
Yes.
My lord, there is a criminal case pending against the petitioner and the disciplinary proceeding has been initiated. The case is at so far as the disciplinary proceeding is concerned, it is at the stage of filing a written statement. My case before your lordship is that if I am, my lord, I have to disclose the evidence in the disciplinary proceeding, I'll be highly prejudiced in the criminal case also. And your lordship is aware, my lord, there are two lines of decisions, clear decisions of the Honorable Supreme Court on this. And although there is no, my lord, fixed proposition as such, it will ultimately depend on the discretion of the court, depending on the facts of the case. Now, the allegations against the petitioner is regarding, my lord, taking bribe of rupees 30,000. That is one. And thereafter, my lord, his house was raided and a huge cash was also recovered from his residence. Now, if he has to file the written statement, my lord, he will be highly prejudiced.
Written statement in the DP.
In the DP, my lord.
What is the stage in the criminal proceeding?
Criminal proceeding, my lord, charges have not been framed as yet. Prosecution sanction has been granted. That is the stage.
But you must be referring to Captain Paul.
Not only
Paul
Captain,
Anthony,
there
is
are
it?
quite
And
a
there
number
are-
of decisions, my
There
lord.
are other decision on the other side also.
Yes, my lord. That's true. But my lord, I'll be relying on Eastern Coalfields, where my
Eastern
lord,
Coalfields.
all the my lord, both type of decisions have been discussed. And it is primarily
That
the
is judgment by Honorable Justice Madan Lakur, is it?
this is by my lord, Honorable Justice Rishikesh Roy. Bench comprising KM Joseph and Rishikesh Roy, my lord. But it has been written by Justice Joseph. I'll refer to paragraph 13 and 16, my lord.
Paragraph 13 and 16. Yes.
We notice that this is a case where there is a criminal case against the respondent. The appellants as the employer also launched disciplinary proceeding. It is undoubtedly true that this court has taken the view that when the charges are identical and gives rise to complicated issues of fact and law and evidence is the same, it may not be appropriate to proceed simultaneously in the disciplinary proceedings along with the criminal case. The rationale behind the principle largely is that the employer who is facing the disciplinary proceeding, employee, I'm sorry, my lord, who is facing the disciplinary proceeding would necessarily have to take a stand. This in turn would amount to revealing his defense and therefore the prejudice the employee in the criminal proceedings. No doubt this court has laid down that it is not an absolute embargo and the principle is one to be applied based on the facts of each case. And in paragraph 16, my lord, we would notice that what is most pertinent is the aspect that in the challenge in the writ petition against the holding of the disciplinary proceeding, obtaining an interim order in the nature of the case was of relevance and importance to the question at hand. The principle involved being when parallel proceedings are held on the basis of identical charges and the same evidence, the employee should not be allowed to disclose his evidence. This subject matter is to be looked into with reference to the effect of.
Yes, he was employee of which department?
My lord, at the relevant point of time, my lord, he is the chief executive officer of the Jila Parishad.
Panchayat, PNRD department. my lord.
PNR.
Yes, what do you have to say?
Lordship, at this stage, charge sheet has not been filed yet, my lord.
Mm.
So we cannot say that same evidence and same witnesses, my lord.
Mm.
So
Then
at
you
this
wait
stage,
till charge sheet
prematurely-
is filed.
Yes,
Till charge sheet is filed,
my lord,
whether his argument has any valid basis or not.
my lord.
You're right.
Yes, my lord,
That can be ascertained only after charge sheet is filed.
my lord.
So till that time, you can't compel him to file written statement.
I leave it to your lordship, my lord.
Oh.
Mhm. Otherwise,
What, leave it to you?
lordship
You are
may
a
fix the
counsel, you-
or lordship
Of
may
course
fix
you
the
have to leave
matter
it
on
to
the
the
next
court.
week, my lord. I'll take instruction.
Is
from-
there an option not to leave it to the court?
No, my lord, my lord.
What is the big deal about it?
Lordship, I am
You
pardon.
will always leave things to the
My
court.
lord, my
The
lord.
judge will pass the order.
My lord.
I'm asking the stand of your
My
client.
lordship may fix the matter on the next week.
Hmm.
Till then, I'll take instruction, my lord.
Yes,
Next week, my lord.
because it is graft charges.
Yes, my lord.
So it's a question of prejudice.
My lord, my lord.
So till the charge sheet is submitted,
My lord,
why should he disclose his defense?
my lord.
After
Lordship
the
is
charge
correct.
sheet is submitted, maybe there nothing can be changed.
My lord,
They have already, the charge is already there. At the most, charge can be altered. And if they do it because of any stand taken in the written statement, that again will be subject to scrutiny by the court.
my lord.
But although the court doesn't subscribe to a view that a blanket stay, but he cannot be made to suffer prejudice.
Yes,
30th will fix it for motion.
my lord.
When is the date of filing?
Wednesday, madam. Day after tomorrow,
Day after two.
24.
We'll make it clear that till next date, no written statement is
Fine,
required to be
fine.
filed. I heard Mr. M.K. Chaudhary and senior counsel appearing for the subject by Mr. P. Varadar and counsel appearing for the writ petitioner. There will be amendments made in the writ petition by referring to the recent decision of the Supreme Court rendered in the case of Eastern Coalfields Limited and others versus Ravindra Kumar Bharti, reported in 2022, bracket close 12 verses 390. Mr. Chaudhary submits that when two parallel proceedings are pending before the petitioner on identical charges, he cannot be compelled to file written statement before the charges are framed in the criminal proceeding, as the same would cause immense prejudice to the interest of the petitioner. On such ground, Mr. Chaudhary submits that filing of written statement by the petitioner be deferred till such time the criminal trial is concluded or at least charges are framed by the trial court. Mr. S. Datta, learned standing counsel PNRD Assam appearing for the official respondents prays for time till 5th of February. 5th of February
My lord.
to obtain preliminary instruction
Right.
from the department and respond to the submission made by the learned senior counsel. In view of the above, let this writ petition be listed for motion again on 5/2/2024 as a fixed item. 2 extra copies of the writ petition be furnished to Mr. Datta so as to enable him to obtain preliminary instruction. Considering the nature of issues raised in this writ petition, it is provided that filing of written statement by the petitioner in the departmental proceeding shall stand deferred till 5/2/2024.
May I submit one more thing, madam? As the impugn order was issued by the personnel A department, my friend also may be directed to take instructions.
Mr. A. Dhar, learned additional senior government advocate Assam appearing for the respond number
1 and 2.
1 and 2 to also obtain instruction in the matter. 2 extra copy each. But this is a
Yes.
point, you see, you can't be, even if a person is proceeded against, this is the fundamental requirement of law that fairness has to be maintained at every stage. You can't push him into 2 parallel proceedings.
My lord.
There, something has to be done. Either you do it yourself or the court will do it. What option is there? Yes.
Obliged.
Please, your lordship. Lordship, we filed additional affidavit, lordship, on last occasion where we annexed 2 copies where we communicated the authority about the order dated 27/9/2022 and another order dated 4/10/2023.
Actually, which order has been violated?
Court Lordship, actually, on first occasion, we filed WPC where
No, no, where is the order? Which page?
an extra 2 Lordship,
Page number?
page number 22, additional affidavit Lordship.
Which order of the court has been violated?
Order dated 27/9/2022.
Yes, where is the operative part?
Lordship, page number 15 in the contempt petition Lordship, para 7 Lordship.
So now the direction was to the deputy commissioner.
Yes, Deputy Commissioner of Police Lordship.
The respondent is deputy commissioner or commissioner of police?
Deputy Commissioner of Police Lordship.
Who is the commissioner of police right now?
Diganta Bora.
He is also the deputy commissioner. No.
He is the commissioner. Commissioner and deputy commissioner, there are in between
You have to implead the deputy commissioner. Not understood.
Understood.
You have implemented somebody else. The direction is to the deputy commissioner. You have implemented the commissioner.
Yes, Deputy Commissioner. Yes.
Deputy commissioner.
Police. CPA.
CP, we have 4. Now, let us find out. Then we have joined, then additional, then commissioner.
You have some problem. That's why don't be in a hurry to get a court order. Hurry means bury. If everybody wants a quick order from the court. And these quick orders are as good as not getting any order. I can't entertain this contempt petition. What do you want to do? Withdraw and file afresh? And then once you implead someone, the question will be, the direction was to him or to whom? Find out what you want to do. We'll have it next week then. Have you understood the point?
Yes, yes, Lord.
You have to give an answer.
Yes, Lordship. Lordship.
And if it comes in some other court, then you will get an order immediately. Because I will have to see what is there.
Yes, Lord. Yes. Lordship.
Last year for a week.
Pending matter for motion item 3.
Maybe before Lordship.
Yes.
Maybe before Lordship. My lord, I'm sorry, my lord. My lord, I would like to withdraw the present writ petition, my lord, with liberty, my lord, to file afresh.
Why you want to withdraw?
My lord, during the pendency of the writ petition, my lord, DLC has placed my application, and my lord, due to my lord late submission, I have been informed that late submission overage, on ground of overage, they have rejected, my lord.
Okay.
So I have to challenge the subsequent development, my lord.
Mr. N.K. Murray, learned counsel, who has addressed this court through RVC, submits that during the pendency of this writ petition, the request made by his client for appointment on compassionate ground has been rejected by the DLC on the ground that he was overaged, and therefore he be granted leave to withdraw this writ petition with liberty to take appropriate remedial steps in the matter as may be permissible under the law.
My lord, in the meantime, my lord, kindly, the respondent may be directed to furnish the copy of rejection minutes, my lord, decision, my lord.
Give it to her right now. Mr. I. Botaku, learned counsel is present for the respondent.
Forest Department.
The Forest Department, and submit that he will hand over a copy of the order of rejection of the application to the petitioner's counsel within 2 days from today. In view of the above, this writ petition stands disposed of as not pressed.
Highly obliged, my lord. Highly obliged, my lord.
Daily list order impleadment of party item.
May it please your lordship.
Yes.
I filed it. I for implead the applicant as a party respondent number 6, lordship. Lordship, the matter pertains to the selection of Garbodan for the search number 13 under Borpeta Revenue Circle, lordship. The petitioner of the writ petition claims to be in the writ petition for selection of the appointment, lordship. He doesn't have any land in the jurisdictional area of search number 13. That is to be reflected by the RTI reply dated lordship 17/8 in page number 48, lordship, on the IA. In reply number
So applicant is the writ petitioner.
no, lordship. Writ petitioner is the Sohidul Islam, lordship. I am Samayan Ali.
Yes.
Lordship, the petitioner.
You want to be impleaded as respondent number 6?
Yes, lordship.
In the connected writ petition.
Yes, lordship.
Who is the counsel for the writ petitioner? Huh? Actually, his name has not been shown. Where is Mr. B.K. Das? Which B.K. Das?
Don't know, lordship.
So call any one B.K. Das. If he doesn't own it, then the next one is the B.K. Das. Can you do it by 12? Let him be present. We'll pass the order in his.
Highly obliged, lordship.
Right now, you call the B.K. Das with whom you are friendly. If he says no, then next one.
Highly obliged, lordship.
Let's see this matter regarding appointment and of Anganwadi worker. The petitioner was selected and engaged as Anganwadi worker in the year 2007. This was challenged by the respondent number 6. The Honorable Court in a similar batch of writ petitions was disposed of along with the writ petition of the respondent number 6. And the direction was given to form committees. Accordingly, the respondent rotated form committees and the findings was given. And as per the findings, I was the impugned order was passed by the authority concerned to remove me from the service. I have challenged this order and the findings by way of this petition. Now, lordship, by the order dated.
So are you serving now? Or you have
Yes, still serving.
Why? There's an interim order.
Yes, lordship.
My lord, we have filed an affidavit, detailed affidavit on 5th January. Affidavit in opposition. So if you want to, my lord, file a reply, then okay, my lord. Otherwise, my lord, fix a matter for hearing, my lord, next week or any date, my lord.
My humble submission, what is that? What I have already announced.
Just a minute. 5th January affidavit in opposition by respondent number 2. Is it respondent number 2?
My lord, the director, my lord.
You have received a copy of this?
Yes, lordship.
No rejoinder is required?
No need, because lordship, what I have already annexed in the petition, they have enclosed these all things.
So what is the stand of the department?
The advertisement, the findings, all these things already I have annexed. These things only annexed. And lordship may kindly see the order of this honorable court, 18/12/2023. The relevant records
my lord,
have been filed.
the deponent Honorable Beck state that as per the photocopy record of the inquiry report submitted by the subdivisional committee, it has been revealed that the petitioner is not a permanent resident of the concerned Anganwadi center. And further, the petitioner does not even belongs to the ST community, while the entire population of the concerned Anganwadi worker is, our center is 100% ST community. Further, the deponent states that the petitioner in writ petition number 5209/2007, as well as respondent number 6, Miss Miju Kumari Dole, is a permanent resident within the jurisdiction of the Anganwadi center.
Next Lordship, may I kindly read the next paragraph. The deponent begs to state that no mention was made about the reservation of candidate in the advertisement was published.
My lord.
No, it's not about reservation. It is about whether
Permanent resident.
Permanent
Yes,
resident.
I have enclosed relevant documents regarding that.
dismiss it because they have made a statement on oath. You don't want to resign that.
I'm challenging the findings also. Kindly see that.
You can't do it. You have accepted their stand that you are not a permanent resident.
No, my
Yes, you are not filing rejoinder means you are accepting.
No,
We will not go into it. We'll accept it.
I have already enclosed the election commission.
Mr. Hazarika, you cannot create your own way of court proceeding. If they file an affidavit
Yes.
stating that you are not a resident and you do not file a rejoinder, the meaning of that is you are accepting it. And just now you said you don't want to file any
No
rejoinder.
affidavit.
So
not-
therefore the writ petition has to be dismissed.
But let me file the.
No. I asked you.
What, Lordship, one thing is that what I have already filed, I have to file again. That is why I'm saying this.
We are hearing, but if it turns out that
Who touched this? I have an next Lordship.
all
In
right,
the,
you are good. But your petition will be dismissed because of your own folly. I'm sorry to say this. You are they are fundamentally questioning your integrity of your application and you don't want to file a rejoinder.
Due to repetition only, I'm saying.
Huh?
Due to repetition means.
What
means,
repetition? An affidavit is equivalent to an annexure you submit in your petition.
Let me submit.
8 weeks time. On the request of Mr. N.M. Hazarika, Learned Counsel for the petitioner, this matter stands adjourned for 8 weeks so as to enable him to file rejoinder in response to the counter affidavit filed by the respondent number 2. Mr. Ardhar, Learned Additional Senior Government Advocate Assam present for the state. Mr. Hazarika, don't be so casual.
Lordship.
Don't be so casual. Huh? If you cannot show that the statement is wrong, your petition will be dismissed, even after you file your rejoinder.
Regarding.
If you don't file it, it will definitely be
So,
dismissed.
Lordship, sorry.
Here in this writ petition, your lordship, we have received the instructions on 16th of December. We would like to file a affidavit. This matter
You are for whom?
for the social welfare department.
Respondent numbers.
Respondent numbers. All the respondents.
Kindly short date maybe you have.
Yes, 4 weeks. Mr. Swan, A.M. Bhuya, Learned Counsel for the petitioner. Also heard Mr. D. Bora, Learned Counsel for the respondents who submits that instructions have been received and therefore he be granted 2 weeks time to bring the same on record in the form of an affidavit. In view of the prayer made by Mr. Bora, which is not opposed by the petitioner's counsel, let this writ petition be listed again after 4 weeks as a 5th item. The affidavit on behalf of the respondent will be positively filed within 2 weeks by serving advance copy upon the petitioner's counsel.
Oblige.
Oblige, your lordship.
21.
May please, your lordship. Lordship, the matter relates to family pension, lordship. On 4/1, lordship, my learned friend was directed to take instructions with regard to some admission, lordship.
Matter relates to family pension means what?
Family pension, lordship, family pension.
The petitioner is a
Lordship, petitioner is the widow of lordship, this is government employee, lordship. He was initially appointed, lordship,
as
secretary of Government Samavaya Committee, lordship. Thereafter, his service was provincialized, lordship, with effect from lordship 22/9/1994, and he died, lordship, on 31/12/2003, lordship. Thereafter, lordship,
So 19 years.
No, Lordship, more than 19 years, Lordship. Lordship. Join on 11/11/1975, Lordship, as Secretary, Lordship. Provincialized, Lordship, on with effect from 22/9/1994. And got retirement from service on 31/12/2003. And died, Lordship, on 27/11/2013.
Why the pension is not been paid?
Lordship, so far, them, Lordship, my service is less than 20 years. So far, their calculation is concerned. So, otherwise, Lordship, my learned friend, by way of their affidavit, have not, Lordship, disputed my initial date of appointment, and I have annexed, in support of initial engagement, Lordship, I annex one RTA reply, served by the respondent authorities, Lordship. That two documents
But
were.
initial period, it was a provincialized service.
Yes, initial service was, Lordship, not provincialized service, but to that effect, Lordship, there was one notification followed by cabinet decision for counting of such period.
Where is it? Where is it? Page number?
Lordship, one. Notification is, Lordship, Lordship, page 21. Type copy 20, Lordship.
Page 21.
Lordship, page 20, type copy, Lordship, and page 21 is in persons of approval of the cabinet held on so and so, and considering the, Lordship, rendered under Assam Cadre Management Cooperative Society Limited prior to provincialization, the Governor of Assam is pleased to allow counting of past services with effect from their initial date of joining in service as Cadre Secretary in respect of the following junior inspector of cooperative societies whose services were provincialized by notification number so and so dated so and so for granting of pensionary benefits, including DCRD, etc., by invoking the provision under Rule 31 of Assam Services Pension Rules 1969, the services rendered by the junior inspector of cooperative societies with effect from their initial date of joining as shown against is shall be treated as government service for pensionary benefits only.
But your client was not inspector of cooperative societies. They're Gaon Panchayat secretaries.
No, not cooperative society secretary, Lordship. Mobile service.
A petitioner was also serving as.
Lordship. My initial appointment is at page, Lordship, 11.
Yes, what do you have to say, Ms. Boy?
Lordship, on last occasion, His Honorable Court has directed me to take the instruction regarding his date of joining, Lordship, and I have filed also affidavit, my lord.
So if past service is counted, then it is more than 20 years.
No, Lordship, Lordship, may kindly have a look my affidavit for a moment. It will clear everything. Page 30 of my affidavit. Affidavit filed by the respondent number 4, my lord. Safiquddin Ahmed affidavit.
Page 30?
Page 30, Annexure 8, my lord.
Yes.
The petitioner name reflected in serial number 1 is Abdul Salam Mia. 14 years, 8 months, 6 days, my lord.
No, page 30 of your affidavit.
My lord.
Is it the running page or internal page?
Lordship, it is the affidavit internal
So
page,
it
my
will be
lord.
a running page of, it's the internal page of your affidavit.
My lord.
The date of initial joining is shown as 25/4/1989.
1989. And date of retirement 31/12/2003. The length of service 14 years, 8 months, 6 days. Regarding family pension, Lordship, we have written to the concerned authority. Family pension, we have no objection, Lordship. Lordship, with the pendency of the case, Lordship. So I think this is not process. but
Family pension, you have no objection.
No objection. We have written to the
That's what he
government also.
wants.
Lordship,
But if you don't give the pension, then how will
Lordship,
you get family pension?
automatically, I will not be entitled to family pension.
Because we have written to the concerned authority, Lordship, may I kindly have a look, this
You know,
annex.
Ms. Bora, he is jumping.
Person concerned is not getting the pension, Lordship. How
No.
family pension?
That's what we are trying to ask.
Yes, that's why, Lordship, we have written to the concerned authority, the last paragraph, my lord. Therefore, for payment of regular pension and gratuity to the government is requested to pass necessary order for relaxation of the condition laid down clause 5 of the Finance Department ON so and so dated and other provision of Assam Service Pensioners 1969 with the concurrence of the Pension and Public Grievance Department for onward submission of the pension papers of aforementioned retired employee. So and so. So we have written to
Actually,
the
that's
Pension
it.
and Public Grievance Department, my lord.
As per Rule 108B, my husband was entitled to pensionary benefit also, Lordship. And to that well effect, there are some judgments also, particularly his judgment passed by the division.
So,
bench
if he was entitled to pensionary benefit,
Lordship,
he retired in 2003
2003, Lordship.
and he died when?
2013, Lordship.
So, did he approach the court?
Yes, Lordship.
What
No,
happened?
Lordship, what happened, Lordship? Notification was followed by Lordship cabinet decision of 2005 cabinet decision, Lordship.
Mhm.
And thereafter, the notification was published for counting of past services. Prior to publication of the notification, he was not entitled. But after publication, Lordship, he is entitled, Lordship.
So, the notification was published long time back
Lordship.
during
He
his
approached.
lifetime.
He approached, Lordship.
He approached.
Approached.
Where is the order passed? by
No,
the court?
no, he had not approached the court, but he approached before the authority, but there were several communications. And after his death, Lordship, I applied for pension, Lordship.
So, what is your stand vis-a-vis page 20 of the writ petition in your counter affidavit?
20, Lordship, we have written to the Pension and Public Grievance Department regarding
Oh,
that.
you are not, you have written, that means you have accepted.
Yes, Lordship, because they have to condone his relaxation. They have to take instruction regarding that. Pension and Public Grievance.
But you're not, same person. Alright, that is finished for this. They are saying, they have written for this, his date of entry, date of joining is 89.
89.
But Lawyer is saying that it is an earlier date. That is the main issue in this.
As per
So
record, we have
that
written.
is hashed out, whether that will even if and give some with the necessary clearance also. See the fact that he's saying something.
Lordship.
In
No, but
fact,
he is saying he joined originally in 1975. What is the document to show that?
Yes, Lordship. Annexure, Lordship, page number 11. Page number 11 is the order, and the list is at page 12. My name is at period number 45. Mia. Travel 7 Mia.
Persons of the same name, and that's why there is this.
My joining also, I have annexed, Lordship, which is
But
at
their
page
father's name
14.
will not be the same, their address will not be the same.
Lordship, page,
Therefore, by the records. for the-
serial number 460.
All right, you
No,
both of you ask your respective clients to
No.
clarify.
In-
We'll have it one more chance and then dispose it off.
Lordship.
My lord-
Mr. H. Talukdar and counsel for the petitioner. The husband of the petitioner, the late husband of the petitioner was serving as a secretary of Samabhai Bhamuka SS Limited under the Assistant Register of Cooperative Societies, Kokrajhar. After his retirement in the year 2003, the petitioner did not receive any pension. Now, his services were provincialized with effect from 22/9/1994. However, after his retirement, the petitioner's husband did not receive any pension as his past services were not counted. Past services prior to provincialization was not counted by the authorities. Subsequently, a cabinet decision was taken to extend the benefit of past services to the junior inspectors of cooperative societies, which was notified on 5/1/2006. According to the petitioner, after the cabinet decision dated 23/12/2005. The past services of the petitioner's husband would have to be counted for the purpose of determining his entitlement for receipt of pension. And therefore, since the petitioner had spent more than 20 years in service, if the services prior to provincialization is taken into account, hence, not only was the petitioner's husband entitled to receive pension under the rules, but even she is entitled to receive family pension. Ms. Bora, Learned Standing, MD Bora, Learned Standing Council, Cooperation Department, Assam submits that the department has already written to the government recommending the case of the petitioner for payment of family pension, but a response in respect thereof is still awaited. Full stop. Mr. C.S. Hazarika, Learned Government Advocate, Assam, appearing for the state, prays for 4 weeks' time to seek full and complete instruction responding to the prayer made in the writ petition. Mr. R.K. Talukdar, Learned Standing Council, AG Assam, is also present. Taking note of the request made by Mr. Hazarika, this writ petition is directed to be listed again as a fixed item on 6th of March 2024. A copy of this order be furnished to Mr. Hazarika. Stop. You download it and
Deeply amazed.
I mean, here what the payment of regular pension. Required to
payment of pension oblique family pension.
Lordship, obliged.
Yes.
Not break, yes.
Number 18.
Who's there? Item 18. Yes, sir, madam.
My lord, the issue was small, but then I'm told the CGSE, my lord, he is not present today.
Your Lordship, my senior is having some difficulties.
Hmm.
May the matter be adjourned for the day?
When?
First week of February, my
Counsel
lord.
for the petitioner is present. However, on the request of learned CGC appearing for the respondents, this matter stands adjourned. Let this case be listed again in the month of February. 2020.
No, we certificate of that. Last occasion, your lordship wanted me to produce the original copy.
Please show it to him once.
That I have already confirmed, lordship. It has genuinely been issued, lordship. I'm only on 2-3 points. And another judgment, your lordship wanted me to produce, to refer. That is, Lord, 2009 7 SCC 284.
Yes.
284. Paragraph 18. You look.
Yes, please.
5 minutes, paragraph 18, 288 page. Yes, Lord. The death and birth register maintained by the statutory authorities raises a presumption of correctness. Such entries made in the statutory register are admissible in evidence in terms of section 35 of the Evidence Act. It would prevail over any entry made in the school register, particularly in absence of any proof that the census. May I pass it?
So what has happened in this case? The facts, just to recapitulate. The petitioner was working as what, a Mazdoor?
Paid for employee of GMC, my lord.
Hmm.
Now, as per his birth certificate, his date of birth is 15th May 1964. That is at page 8, my lord.
Page?
Page 8.
Yes.
So, in terms of that date of birth certificate, my lord, due date of retirement would be 15th May 2014, 2024.
Yes.
But he was prematurely retired on 31st January 2021. Height retirement notice dated 1/9/2020. Now, prior to that, my lord, he was again at one occasion because he was prematurely retired. Then we raised this question, and my death certificate, birth certificate was verified. And that was duly verified by the authority concerned. That your lordship would find at page 11. But instead of recording the date of birth as 15/5/64, they have written it as 1/3/1/1961. Though it was verified, my lord.
So what is the basis of this 3/1/1961?
Yes, Lordship. Lordship, first thing, Lordship, as on date, Lordship, date of retirement is 60 years. So even if a person joins service at the age of 18, Lordship, he cannot go beyond 42 years of service, Lord. In this case, Lordship, petitioner joined service, join means regularize, on 20/2/1980. So his service was regularized on 20/2/1980. That means he joined service prior to that, Lordship, prior to 1980. And this man has already retired in the year 2021. Means he already served 41 years of service, Lordship. If his date of birth is corrected as 64, Lordship, then he will retire in the year 24. That means his service period will be around 45, Lordship, 44, 45, Lordship. That cannot be allowed, Lordship. That is the first thing, Lordship. In 1983, Lordship, one state medical board was constituted. Board certified that his date of birth should be 61. And in the year 2015, when he filed an application along with the present date of birth, Lordship, it was considered thoroughly. After consideration, a decision was taken that his date of birth is corrected as 1961, not 64. An order was passed, Lordship, in that regard. And this is page.
No, is there any statement when he entered service in the?
Yes, Lord. Service book is there.
What is the date shown there?
It is regularization date is 20/2/1980. 20/2/1980.
So even assuming that on that day he was 18 years old.
Lordship, he should have retired in 2022. He cannot go beyond 2022, Lordship.
That's a message.
Second submission will be, Lordship, at page 10 of the writ petition, Lordship. This is an order dated 29/8/2016, by which his service date in his service book was corrected as 1961. Page 10 of the writ petition, Lordship. So a decision is there. His date of birth was considered by the authority. A decision was taken. And his date of birth has been recorded as 3/1/1961.
So he was aware of this.
Yes, Lordship.
No protest against
this. Is not under silence, Lordship. That is my second submission, Lordship. Thirdly, Lordship, FR 8. So this decision was of 1916, Lordship. He has no objection. Thereafter also he continued in service. Immediately prior to his retirement, when his notice was served, Lordship, in 2022, he filed an objection again, file an application again, correct my date of birth as 1964. FR 8, Lordship. All right. Sorry, Lordship. That provision I have to say. FR says, Lordship, a person cannot apply for correction of his date of birth at the fag end of his career, Lordship. Provision to go.
Yes, you are referring to FR 8.
FR 8. FR 8, it is not there now. That provision I am showing, Lordship. In the FR, it is there, Lordship. And Lordship, one further affidavit I found in the record, Lordship. This is an affidavit filed by the petitioner in the year 2003, Lordship. 2003. There he has stated that I am going, along with an application filed by the petitioner for voluntary retirement, Lordship. Here he prays, please recruit my daughter, who was 19 years of age in the year 2003, Lordship, and I want to retire. For whatever reason, that petition was rejected, but in the year 2003 itself, his daughter was 19 years of age, Lordship.
So far their case is concerned, if your lordship come to the annexer.
Just a minute. Have you finished?
No, Lordship, one judgment I will place, Lordship.
Oh, sorry.
Lordship, this is 2023 SCC 411, Lordship, paragraph 9, Lordship.
Yes.
Paragraph 9, Lordship. This court has consistently held that the request for change of date of birth in the service record at the fag end of service is not sustainable. The learned additional Solicitor General has, in that regard, relied on the decision in State of Maharashtra versus Gorakhnath Sharma Kamble, wherein a series of the earlier decisions of this court were taken note of and was held hereunder. 16. The learned counsel for the appellant has placed reliance on the judgment of this court in UP Madhyamik Shiksha Parishad versus Rajkumar Agnihotri. In this case, this court has considered a number of judgments of this court and observed that the grievance as to the date of birth in the service record should not be permitted at the fag end of the service career. Another judgment is, dear Lordship, paragraph 17. In another judgment, in State of Uttaranchal versus Pitambar Datta Semwal, relief was denied to the government employee on the ground that he sought correction in the service record after nearly 30 years of service. While setting aside the judgment of the High Court, this court observed that High Court ought not to have interfered with the decision after almost 3 decades. Some other judgments also there, Lordship. I'm not.
Is he receiving pension?
Yes, Lord. Pension.
Mr. Dasgupta, obtain instruction from your client. Don't press this writ petition.
Yeah, all right, your
It
lordship.
will pose serious problem for him. Because if his date of birth as per birth certificate is accepted, then he has entered service underaged. And that would create problem for receiving pensions also. Everything, his entry will be vitiated. We're getting the point.
Beloved, actually,
He was 18 years old in 1982.
that is their problem.
No, in 1980, service book says he was regularized. But if his birth certificate date is accepted, then he was 16 years on the date of his regularization. And he was appointed even prior to that. That will vitiate the entire thing. That would vitiate his entire entry into the service will stand. It will create a very complicated question of law. Think about it. You understand what I'm saying? If your stand is accepted, then you are in trouble. The only way not to accept, not to put your client in trouble is not to accept your stand. But then there is a birth certificate. That's why I'm saying.
Let me have some instruction.
You are understanding the point, no?
Yes. What your lordship wanted to say that if birth certificate has to be considered, then it will presume that he was appointed below the age, below 18 years of age.
It will have a vitiating effect on.
So I have to take instruction about his entry in the bar.
No, it is the service record is here. We'll go by this. Regardless of what your client says, we'll go by this. Please show it to him. The original service book is here. Whatever is written there, we'll follow that.
Board.
Remover must do. It will date of birth. Regularized. It will regularize. Dead body remover is hereby regularized in his post, height, office number so and so, dated 22/1980.
You take instruction and if we have to write a judgment, we'll have to write a judgment completely, comprehensive judgment. It cannot be. What happens is if the initial entry in service, employing a minor in government job is illegal. Right. So if we find that he was appointed below the age of 18 years, we'll have to declare his entire service illegal. What consequences will follow is a different matter. I'll give you an example. I think there is a judgment, if I remember, that 30 years after the license was issued, driving license, when it went for renewal, it turned out that originally it was issued at a time when the person was a minor. The license was forfeited completely.
It may so happen he was appointed at the stage of minors. It is used to happen. This is the usual thing.
No, but if we today have to write a judgment, we can't say.
Of course, yes, I have understood.
What used to happen is one thing, but what will be the effect of it is another thing. He cannot have the cake and eat it too. He cannot say that I came in as a minor, now give me the benefit of both things. He can't. And then what is the precedent? These judgments will be relied upon as precedent. So we cannot lay down the law that it is permissible.
So
if that was a ground to deny him anything, then approach would be different. All right, you have given him, he's enjoyed, that's all right. But now you are seeking something extra. So the approach will be different here.
no, Millard, definitely I shall take instruction. But Millard, so far their impugn order is concerned, it is stated as per your service record, your date of superannuation. It should be date of birth is 31/61. Therefore, you are directed to hand over the card. That is their case.
Then you give your response, we'll write out a judgment.
Definitely I shall take it.
What to do? We can't help it because you see, as judges, we are also, our hands are also tied. We'll have to answer technical issues technically. Because the problem with this court's judgment, this court means I'm talking about High Court, is that every ratio is binding precedent. We have to. If you want to obtain instruction or examine it, we can postpone. If you want to conclude it today,
without his instruction, I can to withdraw this petition.
yes, and whatever he says will go by the service book. That will not change. Service book shows he was appointed as a minor. It is not that something was taken away from him. Now he wants an additional benefit, which is contrary to what his projection was there in the service book. So either he was appointed as a minor, or
have been appointed as a minor.
That he cannot get.
That shall have to take instruction.
He cannot get that. Question doesn't arise. Mr.
He is a dead body. It appears he was appointed as a dead body remover.
Whatever.
So he might have appointed.
I'm not questioning why and under what circumstances. Those days things were different.
Yes.
But today, if he says that
he was at the age of 60.
We are going into calculation of age, this, that. Then the court cannot ignore that he entered service when he was not eligible.
Might have been appointed at the age of 16 years. It may so happen. I'll have to take instruction.
Many things have happened like this. But when you go into the matter on a technical legal point, then it becomes a different thing. Heard Mr.
But without his instruction, I can't know that.
Preparing for the petition also heard Mr. Nayak, non-extending counsel, GMC Assam, after hearing the submissions of learned counsel for both the sides and on the request of petitioner's counsel. When do you want it?
Can you take it, sir? He is my neighbor.
All right.
I can take instruction. That is the problem with me also.
Yeah. Good neighbor to have. Someday it will be useful. And the request to Mr. Dasgupta, let us have it on 30th January or 1st February, which will be convenient for you?
Any date is subject to
30th January. There's a fixed parliament.
Apply.
Pending matter item 18.
Lordship, the mobile number providing the writ petition I tried, but that has been received by some other lady person, Lordship.
Oh. Then that is the third BK Das. All right, what we'll do is we'll have it next week just to give him one chance, because after that, what happens? People come with a review application.
Okay.
Can you wait for 1 week?
Yes, Lordship.
All right. Heard Mr. D.
D.
Bhavan, counsel for the applicant. Mr. D. Bhavan, GA Assam has appeared for the opposite parties. However, none is present to represent the writ petitioner. OP in this case, although the name of the learned counsel, Mr. BK Das, is duly reflected in the cause list. Be that as it may, for ends of justice and in order to grant one more opportunity to Mr. Das to appear in this matter, this writ petition is directed to be listed again on 24th of January 2020. We'll have it on 2nd of February 2024 for orders as a fixed item. On that day, if it doesn't come, we'll allow it.
Highly obliged, Lordship.
Item 24.
This petition relates to employees of the judicial guest houses, Boka Khat, my lord. My lord, pursuant to orders passed by this honorable court, the petitioners have been paid their arrear salary, and their current salaries at the rate of 9,000 per month are being paid. But the petitioner number 2, he has been recently joined in 2022, my lord, joined as peon under the establishment of district and session judge. His arrear salary has not been paid. Some communications were made to the High Court authorities, my lord, by the session judge, but that has not been paid.
I can take care of that, my lord. I'll communicate the registry with regard to the arrear salary of one person.
Others, they have been
Others are
paid.
concerned, they are
We'll
receiving.
close it by
Lordship, but in respect of the other prayers also, prayer number 1 is still alive. Lordship, may kindly turn to page 16 for the prayer portion, my lord, the repetition. Prayer number 1. But they are being paid salary at the rate of 9,000 per month. Whereas for equal pay for equal work before Lordship sees, my lord, the salary, that part Lordship may perhaps be like.
you approach the court once again later on if there is a grievance.
But they are paid by virtue of Annexus 7, page 26. There is a notification by Government of Assam. Following this notification.
All right, Mr. T. Chakravarti, Learned Counsel, appearing for the writ petitioner, submits that during the pendency of the writ petition, all the petitioners have been granted
Except petitioner number 2, my lord.
pay of casual worker at the rate of rupees 9,000 per month. And they have received the amount save and except the petitioner number 2, in whose case even the arrear amount, arrear salary, arrear dues have not yet been released. Mr. H.K. Das, Learned SC, Guwahati High Court, prays for 3 weeks' time to obtain specific instruction and address this court on the grievance, on the aforesaid grievance expressed by the petitioner's counsel. Registry therefore list this matter again after 4 weeks.
Obliged.
Your Lordship, he was suspended and his suspension was revoked. But there was curtailment of his increment, which were not revoked. So he approached this honorable court. Honorable court directed him to file a representation. He filed a representation, but by impugned order dated Annexure 8, page 34, his representation was turned down by a speaking order. So we are before Lordship. Here what has happened, Lordship, already one affidavit has been filed by the respondent. Lordship will kindly see respondent number 2. Their respondent is saying that they leave it up to the court or to the government. Paragraph number 3.
So what is this leave it means? Can they also say that we don't leave
This
it to
is
the
the
court?
speaking order they have passed, Lordship.
What is there to say leave it up to the court?
This is
Suppose
Lordship, I have
everything is
also,
left to the court.
this is the speaking order they have filed. He passed lordship, but
Speaking order.
but
says-
lordship, my lordship prayer would be lordship may see annexure 8, page 34 of the petition, lordship. The speaking order passed, lordship. It says everything about the lordship case, all facts about the case, lordship. It is, yeah, lordship.
No, the petitioner was placed under suspension.
Lordship. Lordship, he knowingly, lordship, he without disclosing that he was under suspension, he applied for promotion, lordship. Disclosing the without disclosing the fact, lordship. So wrongly he was promoted, lordship. In fact, lordship, authorities should revert him back to the
So,
original post.
The authorities will know whether he's under suspension if the petitioner discloses. They don't have their own record.
This is the how, lordship, this speaking order has been passed.
So what happened? Then he was promoted.
He was promoted. Now he has come for the curtailment
Settlement of the.
to increment,
to
lordship.
increment. Removal
We
of
are,
curtailment
one
to
wrong has been done, lordship. Now another wrong has to be done by the authorities now, lordship.
We'll hear it in March. Readings complete.
Lordship.
But Mr. Abadi-
Lordship, my friend has filed some additional affidavit, lordship. That copy I have not received.
I will give it, I will. Course of the day today.
Still appearing for the writ petitioner. Also heard Mr. N. Upadhyay, Learned Standing Council Irrigation Department, Assam, appearing for the state who submits that copy of the additional affidavit filed by the petitioner has not been served upon him till today. Full stop. It further appears that this writ petition is ready as regards pleadings and can be taken up for disposal at the stage of admission hearing. As such, register to list this matter for admission hearing on a non-miscellaneous day in the second week of March 2024 as a fixed item.
All right, lordship.
Item 27.
Your lordship. Lordship, I kindly have a look, my lord, of your lordship's order at order dated 3/5/23, my lord.
Why so many cases together?
My lord, similar cases, my lord, number of persons.
All are
So
similar.
in all their
cases,
cases, the SLC has recommended appointment.
Yes,
Then why they have not been appointed?
my lord, so respondent number 1 was directed to obtain instruction, file an affidavit, my lord. Till date, they are not responding, my lord.
I'm for respondent number 2, lordship. I have.
The two, one is.
Lordship, I'm going to file my affidavit today only. Just my name was not reflected in the cause list, so I missed the matters. But coincidentally, today I have coming with my affidavits, lordship. I will file the
What is
affidavits
your
today.
for which department?
I'm for animal husbandry and veterinary department.
What is
lordship.
your, all the petitioners belong to the same department?
Yes, ma'am.
Same department, lordship.
What is your stand? SLC has recommended.
Yes.
Yes, lordship. The
Then
total.
you have to comply with it.
Yes, lordship, as per the OM of 2015, lordship, as per our, I'm relying on the affidavit, lordship, the total earmark post to be appointed in compassionate ground was 93. They've already annexed that also, lordship, in their writ petition. The petition has already annexed that
No,
chart in the writ
please
petition also.
tell us one thing.
That is
Just a
5%,
minute.
lordship.
When SLC makes a recommendation, it verifies every aspect of the matter, including vacancy, etc. That is why it is SLC.
Lordship.
After the SLC says appoint, you cannot say you will not appoint.
Lordship,
Well, actually, what happened, my lord, in the respondent number 2 department, there was no vacancy.
no vacancy.
So therefore, it was directed that they may be considered in another department. And after passing this order, my lord, the government has issued an advertisement, my lord, stating there are 13,000 vacancies, my lord. We are not considered there, my lord.
That's our case, my lord.
Other department, which department, for which?
My lord,
position?
it says, my lord, if your lordship turns to page 37, my lord, for a once, my lord.
Mm.
It says, my lord, could not be accommodated due to non-availability of sufficient vacancy, and therefore proposal shall be forwarded to other departments as per clause 15 of the OM dated so and so. That is at page 37, my lord, at top, my lord.
Yes, what is your stand?
So, if your lordship goes.
Mm.
That's the mind.
Mm.
That's. Meaning 11. So, also, it's. Not be. And therefore, proposals shall be forward. The department of, when we will forward the proposal, if asking other department, whether there is any vacant process, for break. That they will do, because let them fight the affidavit first. I have gone to the affidavit. They said that there is no vacancy in their department. So they will write to other departments here and asking if there is any other vacancy. That needs to be done.
By when can you file your affidavit?
Today only, Lordship.
Then let us file. Mr. Anjay Datta, learned counsel is appeared for the petitioners in this batch of 8 petitions. Ms. M. Kotoki, learned, M. Kotoki, learned, standing counsel, veterinary animal husbandry department, Assam submits that she has received instruction and shall file affidavit during the course of this week. Mr. D. Bora, learned government advocate, Assam submits that once the affidavit by the department is brought on record, the picture will be clear, and he would also obtain instruction in the meantime from the state. In view of the above and on the request of Ms. Kotoki, these matters stand adjourned for a week so as to enable her to file affidavit covering all the cases bunched together.
I am obliged.
Item 34.
May I please? My lord, DLC recommended my name, my lord, the lordship will find at page 38. But SLC has not, my lord, placed the matter before for consideration.
Lordship, I obtain instruction whether SLC will be held or not, Lordship. As per the Annexure 16, Lordship, Lordship, it is clearly stated that there is an availability of vacancy, Lordship. If vacancies arises, then it will be considered, Lordship.
So that is for the.
In the other department also.
So that the SLC will do it once it considers.
So we will obtain instruction whether SLC will be held or not, Lordship.
Why SLC will not be held?
Lordship,
SLC, this application is of 2015. SLC has to be held.
in
So
the,
many
in
days
the, in the written state.
We'll dispose it off by
Next
saying
day,
that
no.
it will be placed before the next.
My lord.
Next.
Heard Mr. M. Mondal, learned counsel for the writ petitioner. Peruse the amendments made in the writ petition. The father of the writ petitioner who was serving as a Gram Sevak under the Nairelga development block in the district of Dhubri, died in harness on 8/8/2015. First up, after the demise of the sole breadwinner of the family, the petitioner, being his son, had submitted an application on 31/8/2015 seeking compassionate appointment against a grade 3 post. First up, the application submitted by the petitioner was also duly recommended by the DLC on 14/2/2023 for appointment against a grade 3 post. The grievance of the petitioner is that the state level scrutiny committee, that is the SLC. Is it SLSC? or SLSC, bracket close, is yet to take a decision on the said recommendation, as a result of which there has been undue delay in the matter. Full stop. On instruction obtained by him, Mr. A. Chakravarti, learned government advocate Assam, appearing for the official respondent, submits that the recommendation made in favor of the petitioner will be duly considered by the SLSC as and when the same is convened. In view of the above, without expressing any opinion on the merit of the claim made by the petitioner, this writ petition stands disposed of by providing that the case of the petitioner shall be placed for consideration before the next meeting of the SLSC and a decision be taken in the matter in accordance with law. Full stop. A copy of this order be furnished to the competent authority for doing the needful. Writ petition stands disposed of.
Leave Lord.
My lord, by today, we are filing our counter affidavit, FCIP. May may come up after 4 weeks for admission hearing, my lord.
Yes, he's going to hand over.
Mr. So-and-so, learned counsel is present for the writ petitioner, Mr. VK Jain, Mr. BK
Singh.
Singh, learned standing counsel FCA, appearing for the respondents, Mr. GK Gupta for petitioner. Respondent submits that counter affidavit on behalf of the authorities will be filed during the course of this week by serving advance copy upon the petitioner's count.
I'll be filing the rejoinder after.
In view of the above, register to list this matter again after 4 weeks for admission hearing by tagging the
So kindly fix the
affidavit
dates.
filed by either side in the matter, the parties to exchange pleadings in the meantime.
Can the date be fixed, Your Honor?
Yes.
27, my lord, 27 February.
Huh?
27 February. It is not inconvenient to your lordship.
What is the issue about?
It's a disciplinary proceeding matter, my lord.
5th of March. 5th of March. Is this
Obliged.
Obliged.
I pay for 2 weeks' time to file my affidavit, lordship.
Mr. D. Bora Learned Counsel is present for the petitioner on the request of Ms. D. Bora Learned SC Agriculture Department. Assam. 2 weeks further time is granted the department to file affidavit, list accordingly.
Obliged, lordship.
My lord, in this case, my grievance is that, my lord. I was appointed on 26/9/1991. Along with me, another lady was appointed, that is Mira Swikia, on the same day, the same list. But she was promoted as ward sister on 22/2/2010. I was not given. Thereafter, my lord, she was again promoted as assistant matron on 1/12/2021, but I was given much later. The graduation list, lordship, we have submitted, that is page 34. So my only grievance is this, when my contemporaries have been promoted, first to the post of ward sister and thereafter to the post of matron, assistant matron, that benefit may be provided. Well, that is limited.
It doesn't happen like this.
Hello?
No, you can't make a prayer like that. You will have a grievance if your junior has been promoted or if they're promoted in violation of the rules. This is not a
My
can't
lord,
just walk in and say
contemporary.
whatever you're given.
I am not saying she is my contemporary.
Hmm?
My
Contemporary
contemporary.
is nothing. Is she junior or senior to you?
No, I am, we are same batch and same year we have been appointed.
Then I cannot take up this matter. There
But-
cannot be two people in the same seniority. This kind of argument.
No, there's graduation list was there.
Who is above whom?
My position is at serial number 24 and her position was 29.
She is junior to you.
Junior means in graduation list, her
That
name
is
is,
what is the meaning of
letter.
junior?
that is not junior, but yes, it, for so
Oh,
far
Mr.
marks.
Mahmood, you have to argue it somewhere. I don't understand you create your own jurisprudence.
No,
In the gradation list, who is above is senior.
I am above. I am 24, she is 29.
Then your junior has been promoted.
Yes, that
What is the criteria of promotion?
criteria seniority.
Huh?
Merit cum seniority.
Then you did not
Without
challenge
any
it.
formal examination, my lord, they are
Then
chosen.
at that stage, you did not challenge it. When
At
your
that time, my
junior-
lord, I have come to know about this matter only, my lord, on 2019 when I was promoted. as assistant matron, then only I came to know.
Came to
Because
know about what?
I am at Kachar and she is at Borpeta. So
Hmm.
actually I have no grievance against her. I only want that as her name is below me, so that benefit should.
It doesn't happen like that. It doesn't happen like that. That's not the way legal matters are dealt with. That okay, you give him something, give me also something. This is not how it is. Either you have been wronged or you have not been wronged. If you have been wronged, we'll step in. If you have not been wronged, we have nothing to do in the matter. You have to clearly, what is the matter? She was ignored.
I have not yet received the instructions, Lordship. I have
Oh.
communicated.
Huh?
I have not yet received the instructions. Some time may be given.
Why? You have been given time earlier. How much time you want?
2 weeks, Lordship.
You file your affidavit, we'll give
We are
you
not
4 weeks.
Lordship.
Mr. Mahmood, be very clear about what you are asking for. What you are asking for will certainly not be given by this court. That's not something you can ask before the court. You have to, in a service matter, you have to be pointed
No.
and specific.
Well, I remember your Supreme Court judgment. It
Which
was-
judgment? Show me.
Like my learned friend, contemporary or juniors, that was said there. If contemporaries or juniors are promoted,
Hmm.
then that benefit, that promotional benefit should be also extended to the person who has not been provided.
No,
So,
which is the judgment? You don't have it.
I will satisfy.
You
Let
bring
my
it, bring
learned
it
friend come with black and white, because everything is based on record manner.
Yes. 4 weeks.
4 weeks, Lordship.
And you are appearing for all the respondents.
All the response.
If your client has been superseded, then we'll direct them to do it. There's no question about it. And if the criteria is seniority.
A date may kindly be fixed and an atom may be made to dispose the matter.
Huh?
A date may kindly be fixed.
Yes, yes. Heard Mr. M. Mahmood, learned counsel for the petitioner, also heard Ms. D. Bora, learned standing counsel, Health Department, Assam, appearing for the respondents who submits that instructions as called for are still awaited for filing affidavit. Post of death, Ms. Bora has prayed for 4 weeks further time to obtain instruction, file affidavit. Prayer allowed as last opportunity. Now, last of all, prayer allowed. Register to release this matter again on 18th of March 2024 as a fixed item. Counter affidavit on behalf of the respondent will be positively filed on or before the next date fixed.
Lordship.
Obliged.
Obliged, Lordship. For orders, item 38.
None appears for the petitioner to call matters to adjourn for 2 weeks. Called earlier. Yes, who is appearing?
40.
Yes, what has happened? Did you?
Lordship, may I make my submission, Lordship?
Yes, yes.
Lordship, the matter is about my area.
Did you go to Debrigad or not?
Lordship, I'll explain the matter, Lordship. The name which was given to me is Mr. Talukdar. When I contacted him, he said, I am not dealing with your matter. Then I said, who is dealing with it? Mr. Mohanta, who is on leave for his mother's demise. Then I contacted him and he said, I am a new person in that matter, in that post. And the person who was dealing with my matter, he has retired only 1 month back. So I contacted the previous person And he said there is no signature, nothing, no document required. And if anything is required, it is for pension papers. That is not the matter in this case. Whatever they said was about that pension matters, and the pension matter is not a matter in this case. That's it.
What is the matter, Mr. Chaudhary?
Lordship, here matter was pertaining to payment of arrear salaries and well as non-practicing allowance to the petitioner, my lords. Subsequent amount has been paid. If Lordship will peruse the last order, my lords, then a direction was given to the petitioner to go and meet the authorities in the AMCH. So because certain documents were required to be signatured by the, and the non-roll certificate was required, Lordship. My learned friend has not gone to the authorities from what I've understood, Lordship, and a non-roll certificate, non-practicing allowance has already been forwarded to the AG, my lords. From our end, we have completed all required procedure. His signatures is required, and a non-roll certificate because a period of some 8 or 9 months was left out, my lords. Majority has been paid. 8 to 9 months
13 months.
13 months was not paid for that, my lords, because the record was not present. The petitioner's record was not in AMCH. So during that time, if he was in, as per the claim of the petitioner, he was in Guwahati Medical College. So non-roll certificate was required, my lords, that he has not produced yet, my lords. So that is the only problem which we are facing at the moment. If my learned friend goes and visits the authority.
No, we'll direct personal appearance of the respondents.
No,
And by that time, if the amount is paid to him, they need not come. Otherwise, they.
Lordship, if I may.
Please take your seat. Please take your seat.
Yes, Lordship, if I may submit, Lordship, we just need the cooperation of the petitioner, my lords. We have paid 90%, 85 to 90% of the amount, my lords. Since there are no records available in the department, because of which we are having difficulty paying that amount, my lords, a non-roll certificate.
What cooperation you want?
Lordship, he just needs to visit because there certain signatures will be also
He
required.
said he has visited and.
No, Lordship, may I ask him? Lordship, on the last date, a statement was made that I'll provide him with the numbers and the authorities' number so that he can go and coordinate. Lordship may ask the petitioner, I'm not, whether he has visited.
He should visit and meet whom?
Lordship, I have the number of the principal, the officer who's designated, there's a specific officer who has been designated to look after his matter, my lords. I had forwarded the number and the.
What is the name of that officer?
John Talukdar, Lordship. He is a secretary in AMCH. Lordship, we had contacted him also. Lordship, the petitioner did not go and meet him after that. He have their contact.
John Talukdar is working as what?
He is a section officer, Lordship, of the. Lordship, if he visits, Lordship may just ask the petitioner if he has visited or has he been contacted on that aspect.
There is an order of the court. You have to visit.
Lordship, he's Mr. John Talukdar. He is an accountant in the principal.
Mr. Laskar, you have to visit because there is already an order of the court. You have to visit. Only question is, how much time you want to complete the process? That's the only question here.
Lordship, I had gone there and I had talked to them. I had talked to them, Lordship. I have talked to John Talukdar. I have
You
talked
went to Dibrugarh?
Yes, I went to Dibrugarh.
When did you go? When did you go?
Exact date, like I think 24th or something, Lordship. I have talked to John Talukdar. I have talked to Mr. Mohanto. I have talked to Mr. Bhuya. All these three people.
All right, then please file an affidavit saying that.
Yes.
And then we'll.
Lordship, may I submit the matter? Lordship, meanwhile, I received a letter from Principal Assam Medical College, Dibrugarh, asking me to acquire a non-roll certificate from Principal Guwahati Medical College. Accordingly, I submitted an application to the Principal Guwahati Medical College for the non-roll certificate for that concerned period.
The 13 months which has not been paid, Lordship, basically.
Lordship, the results is awaited. They have not given me any reply, nor have they issued their non-roll certificate.
All right, then you bring all these facts by filing affidavit.
Yes. Lordship, I'll also look into the matter since he has said he has approached the principal. I'll go and put pressure on the principal also saying that kindly issue the non-roll because that is the only thing. Plus his signatures will be required in the AMCH, my lord.
Principal of AMCH.
GMCH will issue the non-roll certificate, my lords, because otherwise the record which was available in AMCH, that amount has been paid. So there was a period of 13 months where there's no record present. So for GMCH, that non-roll certificate has to be paid because during that time, I think my learned friend was practicing over there. Now, Lordship may just grant me some time. I'll follow up with the principal of GMCH as well. In the meantime, if the petitioner can visit the official, he already has the number. If he can just visit them once so that they can get the necessary documentation completed, my lords.
Lordship, I have also intimated Principal Assam Medical College, Dibrugarh, that I have submitted an application for non-royal certificate to the Principal Guwahati Medical College. And this letter is also.
Lordship, there's no receiving of this, Lordship, and I have had a word with the officer today, Lordship. They've said that the petitioner has not visited them, my lords.
And another matter is, Lordship, the non-practicing allowance. The matter is standing in Accountant General's office. And Lordship, I personally inquired with the Accountant General's office, and they said that they want to know from which date I require the non-practicing allowance. So I have replied, I have sent a letter to Principal of some medical college to Accountant General's office that whichever date is applicable as per the rules, till my retirement on 30th April 2018. So I have submitted the letter through Assam Medical College Principal.
All right, so you bring these facts by filing.
That is letter.
Give it. You please bring these facts by filing an additional affidavit.
Lordship, an amicus curiae has also been appointed, my lords, but he is.
But one point I would like to.
Who is the amicus
Place
curiae?
here.
And Lordship, his presence will also bring some clarity into the picture in the matter, my lord. Because he is
one simple.
He has been appointed by the court, my lord.
Regarding the non-real certificate.
Mr. Laskar, nothing that you say will be taken note of. Number one, this is a contempt proceeding. Only 2 persons are contemners here. Anything which is not connected with that, you can go on saying you will not take note of. Because judicial proceeding has a particular code of conduct. So it will not go by whatever you want. We will go by the way of doing it. So if you want the court to take action on what you are saying, you have to file an affidavit bringing it on record. Then we'll take it further because your preliminary allegations are only against 2 persons. All that you are saying, they are not in the picture. Do you want to file an affidavit?
I'll file.
How much time do you want?
7 days.
All right.
Lordship may list the matter after 2 weeks, my lords.
All right. Dr. B. Laskar, the petitioner appearing in person has referred to the order dated 15/12/2023 and submits that although he has visited the concerned officials at the AMCH Dibrugarh and has also applied for a non-royal certificate from the principal, GMCH, Guwahati, no action has been taken in the matter till today. Mr. Cholia, learned counsel appearing with the respondent, on the other hand, has denied and disputed the said stand of the petitioner. In view of the above, the petitioner is directed to file an additional affidavit within a week from today, bringing the subsequent developments on record. Let this matter be listed again after 2 weeks by reflecting the name of Mr. S. Chakravarti, learned amicus curiae in the causeway. You file it within 7 weeks. It'll come out after 2 weeks.
Lordship,
the date.
After 2 weeks,
date.
5th of February. 2 weeks. No, 2 weeks will be 12th of February. 12th of February.
Lordship, Lordship, my learned friend has made a statement in court saying that he has visited the authorities in AMC.
I've recorded.
Lordship, that I'm disputing, Lordship, because as per my instruction.
That's why I let him file an affidavit.
Lordship, obliged.
What is this matter?
It's a contempt petition, my lord. Contempt petition, my lord. It has been preferred for non-compliance of your lordship's judgment. So you'll find the judgment at page 9, my lord.
So anybody has appeared? Service report is not there. You have to take fresh steps then. What is to be done? Service report is not there. On the prayer of Mr. Ayat Saikal and a counsel for the petition, this matter stands adjourned for 2 weeks awaiting service report on the respondent. Mr. Seike, you are not able to respond to a query made by the court? Yes, next matter. Yes.
Your Lordship, by the last orders, on 2 occasions, they've prayed for time to file their additional affidavit. And still date, they've not filed anything. Your Lordship may close their eyes and fix the interlocutory application for final hearing.
Yes. No more affidavit.
Yes, Your Lordship,
will stand.
we have already brought it on record.
Hmm.
But Your Lordship, this issue that they have brought out, that is already covered by Your Lordship judgment at this time of the passing of the, their main question is that, or some other,
So you want to argue it today?
no,
you
no,
argue it.
I don't
Your
think so.
Lordship may fix the matter for final hearing. My senior will come in.
Not today.
Not today.
All right, Miss So-and-so, M. Sharma, counsel for the, you are for the respondent.
For the applicant in the interlocutory
Applicant.
application.
Submits that despite seeking time from this court, the respondent has, the opposite party has not filed any affidavit.
No, we have filed an affidavit in opposition.
In the IA.
We have filed.
Acha. To tell so-and-so, I also heard Mr. D. Senapati, Lanak counsel, appearing for the opposite party, stroke petitioner in the company petition. It is submitted at the bar that this matter is ready as pleadings and can be taken up for admission hearing. In view of the above and on the request of learned counsel for both the sides, list this case again on
Your Lordship, 13th of February.
20th of February 2025. There's a fixed date.
Your Lordship, can it be on some 22nd?
22nd?
22nd, we are out of station, Your Lordship. 28th would be better.
No, the 13th then, Your Lordship, if it's
It's not possible in that week.
27.
27.
27th, Your Lordship.
Yes.
Yes, Your Lordship.
Made for the Lordship. My Lord, perusal of the order dated 5/1/2024 of the Learned Court of Lavazama, it appears, my Lord, that the service upon respondent number 8 seems to be completed, my Lord. So now, my Lord, the respondents, however, has not filed any affidavit till date.
Who is for respondent number 8?
8.
Who is appearing for whom?
I am for respondent 4, 5, 6, and 7, Lordship. It is.
1, 2, and 3, Lord. State Council for Technical Education, ma'am.
So the higher education standing council will appear. Why can't you appear for respondent number 8? Ms. Mahanta? Why can't you appear for respondent number 8? Yes, heard Mr. H. Buragwal and counsel for the petitioner. Also heard
P.
Ms. P.
Sharma.
Sharma. No, Upar Diva. So heard Mr. Anupadhyay and standing council. Irrigation Department Assam appearing for respondent numbers 1, 2, and 3. And Ms. P. Sharma, learned counsel appearing for the respondent numbers 4 to 7. Ms. P. R. Mahanta, learned counsel has appeared on behalf of respondent numbers 8 and 9. In view of the above, this matter is ready as legal service. Register to, therefore, list the matter for admission hearing after 2 weeks.
I'm highly obliged, madam. Deeply.
Obliged, Lordship.
May it please your Lordship, this review application has been preferred by the department, Lordship. Basically on 2 grounds, Lordship. One ground is that, Lordship, under the writ petitioner claim compensation for whatever has been decided in respect of other persons for which the compensation was paid at the rate of 8,16,000 per biga. But she did not prefer, went to the reference code. So she can claim a benefit only under section 73. And for that, she has to file an application within 3 months. He has not done so. And even in that case, she makes any application claiming at par with the other person.
We'll take it up at 2.
Lordship. Oh, first day, Lordship, may issue notice, Lordship. This is the first day, Lordship, may issue notice.
Action. Mr. B. Chakravarti, learned counsel for the review petitioner. Peruse the ground taken in the review petition. Issue notice returnable in 6 weeks. You are appearing for?
For respondent 2, Lordship.
We don't have any grievance against them. Lordship.
Two.
And who's for one?
One, my lord,
One is the
deputy.
private
Private
response.
response.
Has to
Mr.
take
J.
steps
Henry-
by register post.
J. Henry Lanet, SC Revenue Department, Assam has appeared and accepted notice for respondent number 2. Petitioner to take steps for service of notice upon respondent number 1 by registered post with AD within a period of 7 days from today.
Adjournment.
2023. This matter stands adjourned for 12 weeks.
Much obliged, Your Honor. Not obliged.
May I please, Your Lordship? Order is compliant, Lordship.
Mr.
A.K. Das, Lordship.
Kedas Learned Counsel for the petitioner submits that order of this court has been complied with. This N. Borderley Learned Counsel is present for the respondent. In view of the above, this content place hence closed.
May it please your lordship. My lord, the writ petitioner has filed an IA for stay of the disciplinary proceeding. He is a, my lord, computer assistant in the office of the district judge. And on the basis of two anonymous complaints against him and some lawyers, this proceeding has been initiated. My case before your lordship is that on the basis of anonymous complaints, no proceeding can be initiated and there are specific guidelines in this regard. So violating that guideline, the proceeding has been initiated. Now, my lord, when the matter was moved, this honorable court was pleased to pass an order that no final order be passed in the disciplinary proceeding. But the fact remains that, my lord, even after that order, my lord, the proceeding is continuing. So this IA has been filed now. And the respondents have not filed any affidavit as yet. There are clear directions, guidelines from this honorable court also in the administrative side. And there are other guidelines which are applicable. This honorable court has held in earlier cases that those guidelines will be applicable. Now, so far as the guidelines issued by this honorable court, that your lordship will find at page 41.
All right, but technically it is that prayer was made to stay the disciplinary proceeding
True,
in
my
the
lord.
writ petition. That was not.
My lord, the order passed was that no final order be passed. But now, my lord, he is being subjected to the proceeding. That is, in fact, my lord, putting in the event your lordship finally allows this, is my lord, then the proceeding, examination of witnesses, everything will be, my lord, unnecessary.
Then it has to go before the same bench which has passed the order. Otherwise, it'll.
It's not really a modification of this order, earlier order.
No, but then in that case, it has to be treated as a rejection.
Then let it go before.
Then if it is a rejection of the interim order earlier, I'm taking a positive view.
My lord, I understand.
So Chaudhary, these things will create problem. One bench not granting, another bench granting.
Then let it go before that bench.
Let it go before the another. Same bench.
My lord, one thing I'd like to clarify, my lord. One thing I'd like to clarify, my lord, this entire writ petition is based upon the fact that some anonymous complaint was given.
Doesn't matter.
Lord,
Question is, there was a stay interim order prayed for.
already,
Stay of the departmental proceeding.
already there is an
The
interim
learned
order.
judge says no final order.
That's an
So it
interim
is
order.
not clear whether that order was rejected or not. If it was rejected, then this IA will not be maintainable. If it was not rejected, then it will be for the concerned judge to clarify.
Fine, my lord.
What is the other option here? Looks like
Otherwise-
that prayer was not
One,
granted.
one aspect I can clarify to your lordships is that, my lord, this proceeding, show cause notice was not given pursuant to only the anonymous complaint. After the anonymous complaint, there was a preliminary inquiry
Mr.
held.
Das, you are submitting everything which is not relevant.
Let them
I'm
file
sub-
affidavit,
I-
my lord. They have not responded to my writ
Lordship,
petition.
Only thing it is normally when there is a prayer of stay of this departmental proceeding, the court normally expresses an opinion that either this prayer is considered and granted or not granted,
Yes.
or this is the only interim order the court is passing. Here, can you say from that order that whether the stay was considered by the learned judge or not?
No, it
Then-
says only that not to pass any final order.
Yes, but what about the prayer to stay the departmental proceeding?
True.
What has
That
happened to that
finding is
prayer?
not there, whether it was rejected or not, the prayer.
Then, if it was rejected, this will not be maintainable because it will amount to forum shopping
Or-
straight away.
Yes.
If it was not rejected, then why should the petitioner be deprived?
Let the matter.
Only way out is to send it before the same.
Correct, absolutely correct.
But Mr. M. K. Chaudhary, Learned Senior Counsel for the applicant also heard Mr. Kedas Learned Counsel appearing for the respondents. His IA has been filed with the prayer to pass an interim order suspending further proceeding in the departmental proceeding initiated against the petitioner. Mr. Chaudhary submits that on 11/8/2023, the only interim order passed by this court was by restraining the respondents from passing any final order in the disciplinary proceeding. After a careful scrutiny of the order dated 11/8/2023, it is not clear as to whether the prayer for stay of the departmental proceeding initiated against the petitioner was considered, and if so, whether the same was rejected by the learned single judge, since there is no such indication in the order. If it is presumed by this court that the prayer for interim stay of departmental proceeding was declined by the learned single judge, then in that event, the present IA may not be maintainable. On the other hand, if such a prayer was not considered and or specifically rejected, then declining relief to the applicant in the IA may lead to failure of justice. Under the circumstances, this court is left with no option but to direct the registry to place this IA along with the connected read petition before the learned judge who had passed the order dated 11/8/2023 for issuing necessary clarificatory order.
My lord, may I pray that the matter may come up day after tomorrow, because my lord, the next date in the disciplinary proceeding is 25th.
On the request of Mr. Chaudhary, Learned
29,
Senior
no?
Counsel for
29.
the applicant, this matter is directed to be posted again before the appropriate bench day after tomorrow, that is the date.
Highly obliged.
Deeply.
Petitioner was to file the reply against our counter affidavit.
My lord, may I pray for 2 weeks' time to file a reply?
Mr. A. Borwa, Learned Counsel for the petitioner, prays for and is granted 2 weeks time to file rejoinder. Mr. B. K. Singh, Learned Counsel for the
respondents.
is present.
Obliged.
Respondents is present.
But I've been mentioned this case because there is interim order, my lord, and my learned friend has expressed that it will protect us. But now new case is that assistant technician and senior technician not included. That is the problem. Now they apprehend that will be filled up, my lord. The learned friend may clear this matter. That one line, my lord, it includes the technician or senior, because we challenge the group 3 and group 4. It includes senior assistant, junior assistant, technician, senior technician, my lord. That one line observation that will do.
What has been listed today?
Malad, I have mentioned it.
There is nothing, he has not filed any affidavit, this IA or anything like that with regard to this apprehension.
In 15/2/2023, my lord, on the submission of my learned friend, that interim protection is given. Now they said that.
Which case? Which case?
My lord, 50, my lord, 50, item 50.
No, that order was passed on 5046 or 23.
5046, yes.
5046, the other one, the 51. And accordingly, they filed a contempt lordship. In the contempt, there is an order with regard to the fact that nothing has happened.
The
This is a mere apprehension on their part.
But that
We are
too,
strictly following the direction of this honorable court.
1 minute, please.
And then accordingly, the contempt was closed.
so junior assistant, senior assistant, that is covered, but it's not expressed that technician and seniority. That is also same group, my lord, C and D. So that is the problem, my lord. They apprehend that they may fill up this post. Our prayer, my lord, page 80, all four was mentioned. And he also protection will be given to them, but not in express.
So you want this junior assistant and senior assistant, another category should be added.
Yes, my lord, in my prayer it is mentioned, and he also says that you are protected, but now that words are not included. That is why they take the advantage they may take. So there is an apprehension and there is proceeding also.
No, but
My lord, my prayer page 18, my lord, of my petition, my lord, kindly see.
which petition? Which
My lord,
petition?
5406.
The first one, lordship, this item number 50,
544.
5406, the
Yes,
first.
in that order is my lord 15, 20. My lord. And prayer is page 18, my lord. He agreed that yes, all are to be protected.
Because in the last occasion, lordship, the same instruction I placed before this honorable court, probably it is there in the record on 14/9/2023. Based on that, this contempt, the contempt which was filed with regard to the other petition was closed. The junior assistant and the senior assistant.
Now they said that technician are left out, so we are free.
So why you want to take a different stance for
No,
technical?
lordship, we are not doing that, lordship. He may file an application or he may file an IA. In this IA, I will clarify the entire aspect of the matter. We are not doing anything.
His submission may be recorded, my lord, that
We're
he
not doing
complied that the
anything.
other two also included this, my lord, because his submission is all are protected. So not written, that is the
Mr.
problem.
M.J. Borwa, learned counsel appearing for the petitioner, item 53, submits that although there was an assurance given by the learned counsel for the respondents protecting the interest of not only the junior assistant and senior assistant, but also the technical
Technician and senior technician.
technicians and senior technicians. Yet the same does not find mention in the order dated 24/11/2023, thus giving rise to undue apprehension in the minds of those petitioners who are working as technicians and senior technicians. Responding to the above, Mr. Chaudhary submits that at the moment there is the apprehension expressed by the petitioner is unfounded, since there is no move on the part of the authorities to take any adverse action against the technicians as well as the senior technicians. In view of the above, no further order is required to be passed in that regard for the present. If the petitioners at any stage, if the members of the petitioner organization at any stage feels aggrieved in respect of the above, aggrieved in the matter on the above aspect, it would be open for them to file appropriate application seeking relief from this court. Let these cases be listed again.
Lordship, may I pray for some fixed date? There is some urgency in the matter because this, because of the stay order, we are not in a position to
Be
proceed
listed again as fixed items on the 29th of February.
on admission.
Then affidavit also.
Yes, in the meantime, I'll
In the meantime,
yes.
the respondents counsel to file affidavit.
Yes.
Obliged.
Along with the connected matters, huh?
Is the IAM for correct amending the address of the respondent number 6 in the cost item, my lord.
It's title of your writ petition.
No, IA, my lord.
No, mistake is in the writ petition.
No, actually, original writ petition is another address is there. Correct, it is the service was notice was not completed, and thereafter they file an affidavit. We take the from that affidavit record. A proper address was taken.
We'll allow it, but you have to file an amended writ petition. This kind of correction is not permissible.
Last occasion there is an order, my lord.
That is wrong, whoever has passed that order. The court can modify a court order, but court cannot modify your writ petition. That you have to amend. There is no such provision under the law to do it. Any wrong things keep happening, that's another matter.
My lord.
So we'll allow it, but you will have to find an amended writ petition. Nowadays, in any case, if you don't do it,
My lord.
no order will be issued in your favor because everything is CIS generated.
My lord.
Ultimately, you will get the same order with the same earlier thing only.
Fine.
So you don't have any option either ways.
And then I'm going to file amended. And this petition, I will treat it as an amended petition.
That we can do.
As an amendment.
I'm appealing for respondent 1 to 5, except the private respondent. We have filed our affidavit also here. But without going.
What about 6?
6 is private respondent, who is a beneficiary, who is appointed.
We have to issue.
Is necessary party, my lord.
These mistakes nowadays, if you make it, it's a very lengthy process.
Because of that, my lord.
Nothing can be done, nothing. Even if the court allows, the CIS will not accept it. CIS 4.1 version is not going to accept it. You cannot tinker with it. Only if the petition is amended, they will redo the cost title. Other than that, it cannot be tinkered with. Even if there is a court order, it will not register. So we'll issue notice, nothing can be done. Or Mr. N. Bora Learned Counsel for the applicant also have Mr. A.K. Ratna Learned Counsel appearing for the Learned CGC appearing for respondent numbers, OP numbers 1 to 5. Peruse the statements made in the IA. Issue notice returnable in 4 weeks. Since Mr. Datta has accepted notice for the OP numbers 1 to 5. No formal notice is required to be sent to 6 OPs. Applicant to however take steps for service of notice upon the OP number 6, the registered posted. Have you understood, Mr. Bora?
I know.
You sometimes can take deliberately a long time to understand, but this is the reality.
My lord.
And it is time to change.
My lord.
You better understand these things quickly because nothing can be done.
My lord.
Somebody somewhere will say, okay, we give it, and then it will take you another 2 years. No certified copy can be given unless the cost title is amended and entry is made in the CIS.
Fine. You to address the my lord.
Whatever.
Made please. In item 53, I filed an interlocutory application for bring for keeping 15 posts vacant, my lord.
15 posts
We have the information that they have initiated a selection process. They have issued an advertisement by the state level recruitment commission for class 4 post and class 3 post. And the post earlier held by the petition as well as that post also included as per our information, my lord. I am not sure whether it is included or not, my lord. But that be my learned friend may obtain instruction in that regard, my lord. If it is included, then I am praying for keeping 15 posts vacant, my lord. Because I have made an
you can't file an application like this.
My lord, I have filed an RTA application, my lord. In that RTA application also, they have not clarified the entire thing, my lord. So I have annexed that also, my lord, page 24.
So tomorrow somebody will come and say that stop all constructions in Guwahati. Because I don't know, someday there might be some illegal construction.
In fact, from this communication, there is a semblance that they have sought for information to advertise those posts, my lord. That is from the material on record, that is there, my lord.
You wait till the advertisement comes.
Advertisement, they have already issued the advertisement, my lord. Advertisement has already been issued, my lord. I have annexed the advertisement.
And what is your main case in the writ petition?
This is termination, my lord. We have been terminated, my lord. So that termination is under challenge. During the pendency, my lord, now these posts are taken by the given to the state level recruitment commission. They issued an advertisement.
These are posts of
grade 3 and grade 4.
You have been terminated, why?
Because, my lord, they are saying that while recruit us, my lord, actually we are a contractual employee, my lord. That time, my lord, they are saying that no selection was conducted. But our case is that there was a selection process while recruiting us, my lord. And and we have been continuing, my lord. But subsequently, some more persons were appointed without any selection process. And with that, those persons, my lord, we are also terminated from service, my lord.
All right, now let me ask you a slightly academic question.
Yes, my lord.
The court passes an order to keep 15 posts vacant.
Yes, my lord.
That means the public will be deprived of the service of these 15 persons, correct?
Yes, my lord.
After 1 year, 2 year, if your clients fail in the writ petition, you will have to compensate the public.
But in return also, my lord, if we succeed, my lord, then
You
also, my lord,
succeed, then they will have to appoint you. The 15 people will have to be asked to leave.
that absorption, if that absorption is there, my lord, then
It's obviously because the advertisement has come after the termination order,
Yes, yes, ma'am.
petitions have been filed.
yes, my lord.
So if you succeed, they will have to make arrangements, even if necessary by creating superannuary post. The law is very clear on that. They can't say that, sorry, the court has passed an order, but we have already filled up with that. The argument is not permissible.
In that case, my lord.
But your petition is totally speculative.
But from here, my lord, from the document annexed in the IA, my lord, it is clear that they have proceeded with that. Well, whether now these advertised posts also include the post held by the petitioner or not, that is not sure. That is why, my lord, I am praying that if he can obtain the instruction, that it is
This is which department?
AFDC, my lord.
In this case, I'm appearing on behalf of AG Lordship for department as well as for the corporation Lordship. Lordship, their services were terminated because of the fact that they were not recruited by following the proper procedure of law. That is one, and they were engaged against non-existing posts. But that were the two reasons basically on the basis of an inquiry was conducted and their service were terminated. Now, Lordship, so far as this petition is concerned, Lordship will issue notice, we will take instruction. Otherwise, I am opposing this proposition, Lordship,
Well, that's all right.
staying the recruitment to 15 posts.
We'll hear both sides and pass a judgment.
Yes, ma'am.
How much time you want?
Lordship, will pick up this matter after 4 weeks, Lordship. In the meantime, we will file one affidavit.
Mr. N.J. Khatuniya, Learned Counsel has appeared for the applicant. Heard Mr. Khatuniya, Learned Counsel for the applicant, perused the statements made in the IE. On the request of Mr. P. Nair, Learned Counsel. You are also appearing separately or?
Same.
Mr. P. Nair, the counsel appearing for the departmental authorities. This matter stands adjourned for 4 weeks. First, to enable him to obtain instruction, file a benefit. List accordingly.
Obliged.
But in any case, if you succeed, you
Yes,
will
yes,
have to
ma'am.
be appointed.
Yes, ma'am. Obliged.
So whether or not there is any observation, it goes without saying.
Obliged.
May please, your lordship. Lordship, here by this application, the respondent had prayed for 3 weeks further time for comply with the order of your lordship's law. But
My lord, after, my lord, disposal of this case, my lord, I don't know about the subsequent developments because, my lord, I don't have any contact with the client, my lord. So though I tried, my lord, I
in
could not
fact,
get any positive
I
response.
have received today more, just few.
No, I have not understood. What is the IA about?
IA for giving this respondents further 3 months time to comply with the order because lordship directed page number 14, 3 months time to process with the and pass a final order regarding completion and appointment case of the petitioner. So they had processed lordship, but till the finalization was not there. So they an application was filed. In fact, it is mostly to avoid contempt lordship, but now by 3rd January, they have called few persons for compassionate appointment and petitioner's case is also included for physical efficiency test. This is the latest statement. I have filed it in the month of November, lordship. Presently,
So how much time you want?
3 months further time.
With
But
effect from?
if lordship, I have to it will be affected from date of order, then lordship, only 2 days is left, lordship. In that case, I am praying for date of filing of this application, lordship. Because only 2 days if
That
I
is
have-
from 11th January, 3 months time.
No, I have filed it on 29/11. Or lordship may give a date till 31st of March, then it will be better, lordship.
You filed this IA when 29/11?
29/11. 29, first of,
My lord, I leave it to your lordship because my lord, I
Right,
don't
heard
have
Ms.
any
B. Sharma,
instruction
counsel
there.
Preparing for the applicant,
Procedural.
preparing for the applicant also heard Mr. M. Datta, learned counsel. Appearing for the OP read petitioner. Full stop. This IA has been filed with a prayer to extend the time frame provided in the order dated 24/7/2023, passed by this court in WPC number 1891/2022 for a further period of 3 months from the date of filing of the application. So Ms. B. Sharma submits that the departmental authorities are in the process of complying with the court's order, but due to certain procedural reasons, further 3 months' time would be required for complying with the court order. Stop. Hence, this application. Stop. Mr. M. Datta, learned counsel for the OP, submits that he has no instructions, therefore would not make any submission in the matter. In view of the above and considering the facts and circumstances of the case, I am of the view that the prayer made by the petitioner is reasonable, applicants is reasonable and therefore stands allowed. The time period for complying with the order dated 24/7/2023 stands extended for a period of further 3 months with effect from 29/11/2023. That is the date of filing the application. It is made clear that no further prayer for extension of time will be entertained by this court in this regard. The IA stands disposal.
obliged.
That matter, my lord. Regularization of my. But my instruction is my lord, on Friday, last 18th or 19th, my lord, 19th of January. The Advocate General Assam, my lord, gave an opinion that my lord, since the review has been dismissed, the department must prefer an appeal. That opinion, my lord, they put up. The respondent number 8 is yet to take a call. That's what I'm saying, my lord. So he's praying, my lord, sometime, my lord, on 2nd if possible, or at least 7 days time, my lord, so that they can take a decision.
What is the order? Let us see.
Lordship at page 37, my lord. Para 4. There's a direction from this honorable court as well as they have issued some instruction. When there's direction of the court to regularize the services of an employee with effect from any given particular date, it is to be understood that the regularization would also be done in a regular manner in a sanctioned vacant post where all the service benefits will be available to the employee concerned. In an instant case purportedly, in compliance of the direction of this court, the petitioner was regularized, but against the post which did not have proper retention. Consequent thereof, retentions were issued only for given periods where retention orders were there for a given period and for other given period, retention orders were not there and the petitioner was paid the salary and allowances only for the period for which retention orders were there. In the aforesaid background, the communication dated 1/10/2020 had been made by the Executive Engineer Golaghat Division Irrigation to the Chief Engineer Irrigation Assam, stating the entire aforesaid facts narrated herein above, with a request that as the appropriate retention order were not issued in respect of the post where the petitioner was regularized, therefore the salary and allowances had not been paid to him in an appropriate manner. Accordingly, in paragraph 10 of the communication dated 1/10/2020, a request was made by the executive engineer to the chief engineer to sympathetically reconsider the matter and do the needful to accord ex post facto retention to one number of temporary posts of helper, which is presently being held by the petitioner Bhuvan Chandra Das from 22/7/2005 to 29/2020, and regular retention from 1/3/2020 to 28/2021. We do not find any infirmity or unacceptability in the proposal made by the executive engineer, and it was incumbent upon the chief engineer to do the needful and pass the appropriate order. It has been brought to our notice by Mr. N. Upadhyay, learned counsel, Lada, Chief Engineer had again made a communication to the Commissioner Secretary Irrigation Department to the Government of Assam for doing the needful. But equally of the view that it was also incumbent on the Commissioner and Secretary, the Irrigation Department for doing the needful. If the appropriate orders are not passed for the retention, it has to be construed that the direction of this court for regularizing the service of the petitioner from the year 2005 had not been duly complied with by the respondent authorities, which may draw the ire of issuing the contempt of notice. Accordingly, both the Commissioner and Secretary Irrigation Department as well as Chief Engineer Irrigation Department are directed to do the needful as provided in the communication dated 1/10/2020 in the period of 1 month from the date of receipt of certified copy or order. Unnecessary order of retention being passed, all financial consequential benefits thereof be also provided to the petitioner with a period of another 2 months thereafter. In the meantime, the current salary and allowances be continued to be paid. That is the order. Prior to that, Your Lordship, another order was passed by this honorable court in 22 to 2019. That is the earlier order. Passed in writ petition 4381 of 2013.
Page 22, man. That is the main order.
That is the main order.
Yes.
Para 9. In the result, I am inclined to allow the writ petition by directing the respondent authorities to grant the petitioner regularization of his services with effect from the date the respondent number 6 was regularized. However, in view of long passage of time, the petitioner will not be entitled to the entire arrear salaries, but only with effect from the date of filing of the writ petition, that is 27/6/2013, which should be adjusted to the wages he has already received. His pay prior to 16/7/13 shall be notionally fixed only. Further, having regard to the fact that the respondent number 6 has been enjoying the benefit of regularization for a long time now, it is deemed proper that his regularization be not disturbed. Lordship, my order
So
for
he was regularized earlier.
My lord, in page 25. Now, my lord, immediately after the order, which has been passed at page 22, in page 25, the executive engineer, my lord, he regularized the petition without having any approval from the government in the irrigation department or, my lord, from the finance department. Now, the problem started regarding salary. He on his own created a personal post, he regularized it. So, my lord, the second writ petition was preferred, that though being regularized, the petitioner was not getting the regular salary. So the subsequent second order was passed in that subsequent petition.
So you department preferred a review.
Review in both
Two
the,
writ petitions.
against both the orders.
That is this
And those have been dismissed.
Dismissed.
Where is the order?
order
Well, it's
already
from the-
given, but
A loose copy has been given, man.
70
All right, just.
I've checked it, man, it is there.
two orders I
Two
was
orders.
submitted. ma'am.
It is there.
Lordship, what
It is
happened?
there.
Yes, my lord.
Just
What
a minute.
happened in this case, in 2005, the.
Ms. Bhuya,
my
I'll
lord,
just hear you.
My
Give me 2 minutes to
my lord.
understand what. The petitioner was engaged prior to 1/4/1993.
93, from 91 is working. Lordship.
Other person with the same name.
Yes, my
He got. the
benefit came in my favor in 2005.
That is a admitted position.
Lordship, benefit was
So,
given
my
to
lord, the
somebody else with the
personal
same
post
name.
that were, my lord, issued, my lord, sanction, all were filled up.
Can't help it. You have to create a superannuation post. There is no way out.
Yes, my lord. So, but I pray, my lord, on
Directive
second of,
personal appearance. Nothing can be
second-
done because now what can be done? The order is passed, review is dismissed, no appeal by the state. I think court has shown enough leniency. Let us not stretch things beyond a limit. Because he is otherwise entitled, he has been given it, he doesn't know whether executive.
if the lordship will kindly reflect in today's order, let me communicate it, my lord. Then, if not, my lord,
No,
today's order-
what will you communicate?
my lord, regarding that compliance part.
No, but what is the big legal hassle here? It's not it's about one individual. Then why so much of anything personal about him? Then
Not that case.
these are people, they have worked as musteral workers since this man has worked in 1991. What is the huge issue involved in this?
Yes, I personally, my lord, I have nothing to say, but Lordship will at least, my lord, the last chance grant me time till 2nd of February. Lordship will indicate it something strictly in the order. Let me at least communicate it. Because the opinion came on 18-1. They otherwise also, my lord, being the something, my lord.
Take down heard Ms.
Like a-
B. We are learned senior counsel assisted by Mr. So-and-so appearing for the petitioner. Also heard Mr. B. Gogoi, learned counsel appearing for the respondent number
8 minutes.
8. Mr. N. Upadhyay, learned counsel has appeared for the
2, 7 and 9.
respondent numbers 2, 7 and 9. It appears that alleging willful disobedience of the order dated 27/10/2001 passed by the learned single judge in WPC number 5643 of 2021. This contempt case has been filed. Full stop. Despite receipt of notice, the respondents have not complied with the direction of the learned single judge, whereby an order was passed to regularize the service of the petitioner who was appointed as a casual worker stroke master role worker way back in the year 1991. What is the date?
May 1991, ma'am.
Way back in the year May 1991. Full stop. It is apparent that even under the decision of the cabinet, the petitioner was entitled to be regularized in service, and the learned departmental council has not disputed about his entitlement to be regularized. Notwithstanding the same, the petitioner, and despite the fact that his services were earlier regularized by the concerned executive engineer, the said position has been altered, apparently on the ground that there was no retention of the post. The state has preferred a review against the order dated so-and-so passed by the learned single judge, but the review petition has already been dismissed. There is no, admittedly, there is no appeal pending against the order passed by the learned single judge. Notwithstanding the same, and despite giving opportunities time and again, the state has not complied with the simple and straightforward order of this court, and there is no justifiable ground furnished by the learned departmental council for not doing so. Full stop. Therefore, it is apparent on the face of the record that this is a clear case where contempt of order of this court has been committed. Full stop. Therefore, this court is of the view that appropriate order deserves to be passed in this case, initiating proceedings for contempt of court against the concerned officials. Full stop. However, taking note of the request made by Mr. Gogoi, this matter is directed to be posted again on 2/2/2024 for necessary orders. On the next date, appropriate orders on initiation of contempt proceeding against the respondents will be considered by this court. Parties to come prepared accordingly.
I'm obliged.
But this is quite illogical. We don't understand. Person who works in regularization, what is so big about it by the state?
I have conveyed already.
What is so big about it? Is there any other agenda in these things?
Otherwise, no, they are.
No, but if it was a post 94 engagee 1494, then also I would have understood 93. He's a May 91 person. You have to give him a regularization. We'll take a strong stand in the matter. Let us see what happens. But this is very unusual. This conduct of the state officials is very unusual in this matter. It is not that thousands of people are being regularized or anything. It's not a huge case of financial implication also. But in any case, don't ask for adjournment on the next day. We'll pass appropriate orders. Yes, anything else?
Problem.